Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Hang on one second. I'm trying to figure out how to do this because it's audio only. I might need some technical assistance here in a second. So just see if this will work. So here's the thing. How can I do an audio only call? Melanie Little. Can you guys hear the phone call that I'm on? Yeah, it's only audio. So I have it. Like I have a MacBook and I can call on my phone using my MacBook, but I don't know how to let you guys hear it. Like, is there a way to do it through Skype? No, meaning that, oh, you can't hear it. Mic it. Oh, sorry. I got to change my mic setting. Thank you. Okay, there, I'm on auto now. So you can't hear it. How can I share audio from my computer? I don't know. Use Zoom. It's not a Zoom. Can you call, share the call, or unmute and share? We need tech support. Put it on speaker. I mean, I guess I can call on my regular phone and put it on speaker. If I transfer it to my phone, hang on. Let's do that. Can you hear that? I don't have WhatsApp on my computer. You can hear it? All right, well, I'll hear it when it comes back on. Barely audible, in and out. When I move the sound cuts out. All right, is anybody else playing it? Well, I turned it down for now. Oh, we're just learning. Thank you, Mr. and Mrs. Smith. Is anybody else playing it? Use a Google Meet on Chrome. Share the screen. With that tab of the meeting, make sure the audio is on. Can I call a phone number from that? All right, let me hang this up. I can call a phone number from Google Meet. I've never done that before, but okay, we're learning. We're learning. Okay. It says enter a code or nickname, though. Hang on. No, you can't call a phone number from that? Oh, we can hear a little bit, but your microphone audio settings might make... Oh. Old school. Hold it by the mic like a tape recorder. Okay. Tom's CPU doesn't have it. Cutting in and out. Well, I turned it off for right now. Is it a Zoom phone number? No, it's like a regular dial-in, like 866 number. You can call a number using Google Meet. Me and my husband do it daily. All right, look, we're gonna give it a whirl. Now you can get and make calls. All right, let's try it. Calls. Oh my gosh, you guys are so wicked smart. Hang on, let me go back to the phone number. And then I think if I can share the tab with you guys. Oh, we are cooking with gas, but we gotta hurry because it's 11:57, and I don't know if they start on time over there. Hang on. All right, we're gonna try it. You're calling someone who can't receive calls? What? One 866 I mean, it says share a Meet link instead. Google Voice is not allowing me to do it. It's not allowing me. Oh, I know what we can do. I can take my headphones off. Let's try this. And I can use the speakers to play out. Let's try this. And I'll call on my phone and see if it'll work this way. If it comes out the speakers from the iPhone. Let's try this. It's going to be a little bit old school, but we're going to try it. Audio.
No passcode digits were detected. Please re-enter your passcode, followed by the pound sign.
Can you hear that? Can you guys hear that? Hold on, I got to put the passcode in.
Your passcode has been confirmed. If you need technical assistance during your call, press *0. After the tone, please state your name, followed by the pound sign.
Melanie.
Thank you. There are 10 parties in conference, including you. The leader has not activated this conference. Please stand by until your call begins.
Teamwork makes the dream work. Well, now I can turn it down until it gets started. Oh, teamwork makes the dream work. You guys are awesome. Mercury retrograde could never keep us away. Never. We're muted though. Oh, isn't this fun? We're going to be able to do it. We're going to be able to cover Aidan's hearing. It's audio only. I'm muted. Yeah, I did. Thank you. I know. Free Billy Tibbetts. Free my boy, Billy Tibbetts. Apparently they tell me Billy Tibbetts is a really bad guy, so I don't really know, but I love you with all of my heart. If I don't see you soon, I'm gonna die. That is from The Godfather. That is Clemenza's meatball scene. I don't need these anymore. Woo. Feels good not to have those in. Yes, Melanie for the win. We're gonna be able to do it. If you Google Clemenza's meatball scene from The Godfather, you will hear what I'm talking about. Michael, tell the pretty girl you love her. I love you with all of my heart. If I don't see you soon, I'm gonna die. Tracy Walker's here. She gifted 10 memberships. Thank you, Tracy. We're ready for the hearing to start, so I'll just turn that little annoying music down. And for the 10 members who were so randomly gifted by Tracy, thank you. I hope we don't get struck for whatever this elevator music is, but you know, it is what it is. BC, thanks for the 5. I always sing the intro song, but now my toddler is dancing with me. Oh, I love that. I love you with all of my hot cupcakes too. And Mr. and Mrs. Smith are back. They followed us over here from LA and threw in another 50 into the pot. Hey, it's Chaos Coordinator says, use a Google Meet on Chrome, share the screen with the tab in the meeting, make sure audio's on. You know what I did? I called for my iPhone on my MacBook Air. I fixed the MacBook Air speakers to come out instead of the audio through the mic. And so I did it. I jerry rigged it. HMT Warren became a member. Welcome. Kayla's here. Brennan's lack of self-awareness. Well done. Well done, girl. Says my 8-year-old daughter, and I know every word to your amazing intro. Thank you for showing up because navigating this mess without you would be a nightmare. Thank you. Thank you for thanking me. And hello to your daughter. Hello to your 8-year-old daughter. Mama, she is here. Yay, you did it. I did it. I can be innovative and creative when you guys help me. That was a brainstorming thing. Glamasu says, can Mike Crawford link in if he cannot get on as his phone is messing up? What do you mean, can he link in? He can come over. He can come over. Sure. Sure he can. Thank you, Suze, for your super chat. All right, so AIDAN Kearney's in court today on some new charges that happened the other day. And I said that last night on Glaire's show, he did a fundraiser for Karen Reed. He raised over $20,000. Does anybody know what the final number is? Something like 22,000. I said, for the record, Glaire and AIDAN were both on the stream when I came on, and as was Olivia. Hey, Olivia, if you're here. And I said, for the record, you two, if I was with you two, first of all, I would have never said, let's go to CF McCarthy's ever. Wouldn't have been there. And also, I said I would have grabbed you both by the ear and I would have pulled you away from that D&E pizza. But here we are. He's being arraigned today on the alleged witness intimidation charges that just happened. I think it was last week, $22,700 they raised. That's incredible. Around 23,000. That's incredible. And I said, I never would have allowed that to happen. And I was funny. I was like being a mother. I was like, you guys, really? You guys, really? Did you really? Like, come on. Come on. Let's just make it through the trial. So now he's being arraigned on these new witness intimidation charges brought by Chris Albert, who has a direct line apparently to Tully because he emailed him the video and said, this just happened at D&E Pizza. And Glaire had his hands behind AIDAN, like through, like the little like Muppet hands. And AIDAN said some things on the camera like, I wish that he was still alive. And he was referring to the guy that Chris Albert killed with his car, by the way, Peter Berger. He wasn't talking about John O'Keefe. And so they cut that part out of what they told the judge last week when they were in there. And I did scold him because who needs more trouble? They were miming out the window. Yeah. And the thing is, Bederow sent a letter. He said, listen, he said, Chris Albert, your town selectman, Chief Rafferty, he sent a letter to Helena Rafferty. I don't really care how she pronounces it, quite frankly, is the chief of police in Canton. And he sent a letter to her, a Bederow letter that said, by the way, your town selectman, your boss, has been illegally wiretapping people because not only does he have a video camera, he also has an audio. And he's capturing audio of everybody who walks by his pizzeria. And that is against the 2-party consent requirement in Massachusetts. So there's that. And he said, you must prosecute Chris Albert or you're just going to prove to everyone in the county that you are selectively prosecuting your witness intimidation statutes. And has Helena Rafferty responded yet? I don't think so. Do you think she will? I doubt it. Yeah. Helena, LOL, Rafferty, right? The one who's like, no tampering, LOL. That's the way it records. And she put a little sticky note. She put a little sticky note on the evidence of the inverted Sally Port video and said, that's how it records. LOL. LOL. No tampering. LOL. Josh, hi Josh. Things at 5. Shouldn't the audio recording of Turtleboy be excluded as evidence because it was illegally obtained? I don't know. That's a great question. We don't even know if he's going to actually, catch charges on this, or if they could be dismissed today, or he could be held in violation of his bail conditions, and his bail could be revoked, and he could go back to jail today. Depends. He said that the judge who likes him in Stoughton is on vacation this week, and so it's going to be a random judge. We don't know who it's going to be. So if it gets that far, could it be excluded? Yes, it could be. We don't know if there's going to be charges. That's what we're here for. Eden has another hearing at 2. Brennan, this AM. I thought Turtle Boys was talking at. Aiden has another hearing at 2, and this one at noon. Marianne, truth teller. I'm being confused. I'm getting confused. K-Mac, why doesn't Karen Reed go up to the sidebar? Does this vary from state to state? I think it depends on what they're talking about. And so I don't remember what they were talking about at the very end when she did not go up to the sidebar. Usually she does. Sometimes she does. She did this morning when the judge wanted to read her colloquy. And yes, every state has different court rules. So yes, that's the answer to that part of your question. Thanks, Josh. Brenda Bombard, praying hard they don't revoke his bail. Yes. Put some prayer hands up in the chat. Mr. and Mrs. Smith gifted another $100. Thank you so much for the super chat. Says we will be vigilant. We will be vigilant. Seems this judge jurisdiction whole Massachusetts or Mass are manufactured in all ways. I hope AJ will call it out for after the fact. Oh, he will. There's a gag order in place now, though, so he's not allowed to speak to the media or anyone. None of the lawyers are, including Hank Brennan. Interesting to me that the documentary, okay, Defense Diaries is in here asking me questions, says Scott, but I'm not on that column. I'm on a different column. I'm in the super chat column, so I'm not following the chat. What do they need to know? Hold on. Bob's asking if it's Google Meet or Zoom. It's not. It's neither. I'm calling on my iPhone, on my iPad, on my iMac, whatever the hell this thing is, a MacBook Air, and then I've got the sound on because it's only a phone call. So is that your question? So if you can make a phone call through your computer, that is what the thing is. He's in the wrong courtroom. I don't know. Ali, is he in the courtroom? I cannot. They're hieroglyphics. He thinks he's in the wrong courtroom and doesn't have the Google. It's not a Google Meet. It's a phone call. It's an actual phone call. Okay, Bob, I'm looking at him. I'm going to send Ali the information, but it's an actual, you have to make an actual phone call. It's not a Google Meet. It is a phone call. It's like old school. It's like old school conference calling, like 3-way party calling. Hang on. Okay, there's the phone number. I sent it to Ali, and then I'll send you the passcode. Just got to cut and paste it. So hold on, everyone. Ali, you owe me for this. All right. Okay. Maeve says, I'm glad Aiden investigated this, but OMG, common sense. He inflames them. Yes, he does. He does. I know. Thank you, Michelle. Love you on your channel. Turtle Boy needs to stop. We need him free, not in jail to help with the Karen Reed case. Yes, 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 we do. Thank you on top for your super sticker. Appreciate you. Really? Potsy says, Peggy O'Keefe walked by me in court. She said to the court officer, what the hell is he doing here? In case you were wondering what the purpose of adding me to the witness list was, she just said it. Wait, is Aiden, is that you? Is that your fake name? Are you under a different name, or are you cutting and pasting something that he tweeted? Potsy. Potsy, like from Happy Days? Oh, he tweeted that. Okay. 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 All right. That was from Aiden. Okay. He's quoting Aiden. Okay. I'm like, Aiden, did you forget it was at your sock account? So we're just listening to this really unfortunate music, waiting for the hearing to start. Hold on. Okay. So at 12 o'clock, there's this hearing. And then at 2 o'clock, Brennan is going to the motion to dismiss. Is that going to be in this same courtroom, or is that going to be back in Norfolk County Superior? Because right now we're in Stoughton District. Mr. and Mrs. Smith, thanks for another thing. We have to pick a case to present in our Trial Lawyers University. This is my case now. Listen, I will tell you a funny story because we went over this. Somebody sent this to me. The Colorado high school mock trial competition is using this case. I've got the papers. If you want me to send you the papers, I'll send them to you. Just email me. My email is in the show notes below. I can send you. It's already done, so you wouldn't even have to draft anything. They changed the name of the case, I think, to Karen Snow, but it's the same set of facts. And I'm a proud alum of the University of Colorado in Boulder. Go Buffs! Coach Prime is here, and he's amazing. And we're gonna have a really good season, but it's already been done. So I have the entire package. Mr. and Mrs. Smith, if you want it, email me. I'll forward it on to you. Thank you. And you're welcome. Thank you. And you're welcome. Michael, if the judge grants the motion to dismiss for Aiden, then is the harassment a moot issue? It would be moot, not mute. M-O-O-T. I'm sure that's just a typo. In the Karen Reed case, let me think about that. Yes. I would say yes, it is. Because if those charges are dismissed, there are no outstanding pending witness intimidation charges, right? Are there any other defendants out there who have pending witness intimidation charges against any of the witnesses in the Karen Reed case? I don't think so. True Proposed Pirouettes is here. Karen Snow. The second choice was Karen Hightop. Well done. Well done. Go mock trial kids. Yeah. Yeah, we pulled that up one day. This trial's making new criminal law. Well, this is going to be the case that they're using. Some very unfortunate hold music. Is he tweeting from the courtroom? Hold on. To tell us what's happening and why we're waiting on this unfortunate elevator music stream. Let's see. Hold on. Oh, he did say that. He said, as Peggy O'Keefe walked by me in court, she said to the court officer, what the hell is he doing here? In case you were wondering what the purpose of adding me to the witness list was, she just said it out loud. They promised her that it would keep me out of court. Well, it's interesting, though, because remember during the first persecution of Karen Reed, there was a special dispensation given to Gretchen Voss, who is the reporter for Boston Magazine, that even though she was on the Commonwealth witness list, she was allowed to be in court the whole time. Well, why couldn't Bradl and Bederow make that same motion on behalf of AIDAN KEARNEY? I mean, they could if the judge is going to allow Gretchen Voss to sit in for the whole trial. Why wouldn't they allow AIDAN KEARNEY to sit in? I mean, what's good for the goose, right? What's good for the goose? I don't know. I don't know. What other hearing does he have today? Was it planned or did it come out of the blue? I don't know if somebody could email me like the actual details on that because I'm not quite sure. I didn't realize there was another hearing at 2 o'clock. But if it is, it might be in a different It might be in a different courtroom. It might be in Norfolk Superior. Oh, so wait, is there also a Zoom on this? Let me try this. There may also be a Zoom, and if there is, then that would be kind of cool because we could we might get video. But as far as I know, it hasn't started yet. Hold on. I just want to join from my browser because otherwise it doesn't work. Do, 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 do. Talk amongst yourselves for a second. Talk amongst yourselves, as Linda Richmond would say. Just talk amongst yourselves. As far as I know, what do you mean? Please try your call again later. Just when I figured out how to do this. I don't. Maybe they won't hang up on me. All right. Going back to the old setup. Hang on a second here. We have a Zoom room that has not yet started. And it looks like it's Judge Collins. I don't care who's using what and whether how their sound is. We're using whatever we're using, and that's what we're using. So there's that. We're waiting for now. There's a Zoom. Okay. They're getting everything set up. He's not in yet, unless. All right. So now we have a Zoom feed. So we got that going for us. It's better. Rachel says scammers are targeting Free Karen Read supporters with malware that can steal passwords and login information of accounts. Please do not click links in comments section of news articles. Okay. I cannot speak to the truth or veracity of that, but I would never advise that you click on links of anything, ever. Wasn't the hostage video used in a Don't Do This? Yes, it was. I think it was David Yannetti who said that. He has a friend who's a law school professor who said that they're using it as what not to do. What not to do as a district attorney. You are correct. Thank you, Dr. Russell is the GOAT, for tuning in from Norway. Danielle says, do you think Karen's saying she pulled glass out of John's nose will hurt her? I don't know what that was about. She did say that in the documentary last night, that when she went over to his body, there was a piece of glass on her nose and she pulled it out and it started bleeding. I don't know. What if that cocktail glass was part of what was found? Been tuning in for a while now, never comment. Thank you for your constant coverage. Thank you, Danielle, so much for your 20. I appreciate you so. I don't know what that is about. I don't know what if John O'Keefe walked into the house with that cocktail glass, and then when he was brought outside, if he was brought outside, they said, well, anything that came in with him has to go out with him, like his phone and the glass. So I don't know. I don't know. I'm sure a lot of context was cut out of that. John left the bar with the glass in his hand. Right. She also said in that documentary that John took my vodka soda drink out of the center console when he got out of the car. It may be that the context around that was he took my vodka soda out of the waterfall and brought it into the car and then took it with him. And it was full because I never drank it. Andrew said she probably had to take the glass out to do CPR. You have to pinch the nose. Yeah, she said she did do mouth to mouth, right? Yeah, the taillight is not glass, correct? She said full vodka soda. That's right, she did. She did say full vodka soda. What did you guys think of that documentary while we're waiting for the Zoom to start? Carrie says, I don't know, but dead men don't bleed. Adds more to he was tossed on the lawn early morning hours. Oh, that's a good point, Carrie. That is the good point. Bradl is in with the DA right now. Okay, well, it says the host is here. Can you confirm that it's Judge Collins? Kelly said she actually liked the documentary. I thought there was way too much, people we've seen in every single other documentary, like the Tara, that woman who was John O'Keefe's girlfriend 20 years ago. And yeah, that one, Mama She. And then that guy Brendan, who's been in every single documentary that they will let him on. And then I don't know. Where did y'all watch it again? It was on Discovery ID. And then I think it's streaming on Max, people are saying. Agent O'Donnell is here and says, please do not revoke Turtleboy's bail. Stage 5 clinger. Well done. I mean, the host has joined, so I'm assuming that we're in the right place here. And of course, we would like to have video too, so that'll be so cool. Crystal says, I watched it on Max and thought it was presented well so far. I mean, I think in the end, it's going to be completely anti-Karen. Yeah, she's wearing his badge number on a necklace, this woman, Tara. It's weird. It's really weird, in my opinion. Michigan Meg says they can't even believe that Hank gets away with such lies, and Bev makes sure to degrade the defense on live TV. Yeah, that was pretty wild, that hearing, wasn't it? It's pretty wild. I thought the motion to dismiss was already argued for Aidan Kearney. Didn't we already watch that hearing? Am I conflating my cases again? Maybe I am. I could be. I'm sure somebody will send me that information. Susan's always on it. Susan's always on it. Thank you, Michelle. Your Venmo, who says I'm in awe of how often we say the same things at the same time. We're often outraged simultaneously. Thanks for all you do and keeping us grounded in a kind and classy way. Oh, thank you so much, Michelle. I appreciate you so very much. Well, the good news is we got a Zoom link instead of just an audio link, and the bad news is they're taking their time. Thank you to Colleen, who sent a Venmo, who says, Free Karen Read. I'm an ongoing watcher, also an RN. Just explained contra coup to my hairdresser. Brennan should stick to law, maybe. Yo, thank you, Colleen. I appreciate you. Samantha says, I'm behind and will be behind all day. I'm so thankful I can fast forward through Breenan's spewage. Thanks for bringing the hearings to us. Thank you so very much. Appreciate each and every one of you, even more than you know. Maria says, she sends $30 and she says, thank you. This is for the 30 lies Brennan will tell. Thank you, Marie, for your Venmo. Oh, me myself says, I just pulled cards for Aiden and I have mixed feelings. Talking about tarot cards? Isn't Mercury also in retrograde? Thank you, Julie, for your matcha latte, who's thanking me for my commentary and says it's going to be a long trial. Oh, it's going to be a long trial. The last thing we saw argued in open court was Alan Jackson asking for a continuance of the April 1st trial date because of the federal appeal. And he said that they filed their brief today to the First Circuit. And then the attorney for the Commonwealth, who's handling the appeal, Caleb Schillinger, said their brief will be filed by Monday. And then the reply brief is due by Wednesday. And they don't know when the federal First Circuit court will rule on that, but they're asking for an adjournment because the federal circuit court, the First Circuit Court, may stay the trial anyway. And also, he says that if, God forbid, he didn't say God forbid, but he said if we pick a jury and jeopardy attaches, once we pick a jury, jeopardy attaches. And if jeopardy attaches and the federal court then comes in, or the First Circuit Court comes back dismissing counts 1 and 3, we're going to have to ask you to either to dismiss all the charges or to disband the jury and start all over again because jeopardy has attached. So it would be in the interests of judicial economy and justice for us to just adjourn the trial, right? So there's that. All right, excellent. Tom CPU is in Stoughton, says it hasn't started yet. Thank you, Lisa Macy, for the update. Appreciate you. Carrie says, yes, Mercury retrograde. My software for radiation was down yesterday. 2-hour delay. Hope it's working today. I'm so sorry that you're undergoing radiation, unless you're saying that you work in a place that gives radiation. But if you are undergoing radiation, sending you all the healing vibes that I can muster. Or they could drop charges 1 and 3, says Lauren Mars, the 99. But, do you really think that would ever happen? I don't think so. You're welcome, Kathleen. You're very welcome. Resting Bianch face says the Turtleboy will be fine. He did nothing wrong. Albert is the one who should be worried. He's been illegally wiretapping the entire town. He's on select board 4. Yep. Yep. I'm with you there. Leona Henderson says it sounds like another one of Chris Albert's cries. He's scared of Turtleboy. Sounds that way, doesn't it? Oh, wait, Bederow did say that Rafferty wrote him back? Really? Huh. Well, that's interesting. And Jade says Venus is also in retrograde in Aries. Well, let's see. While we're waiting for the Zoom to start, maybe I can read the Bederow letter to you. If you like we can have a reading. I won't put it on the screen though, because we're waiting for the Zoom to start. Terry said, I ordered a sign for my yard because of the cameras. Do you live nearby? What camera? The news cameras, you mean? YouTube is glitchy. Can you guys still see me? Because YouTube is not even letting me like go on to my own live. It says that it started that it ended 42 minutes ago. Because YouTube. I also noticed that YouTube, I got a new phone and YouTube looks really blurry on my phone. I don't know why. It's because my phone is too high tech now. Now I finally got a decent phone and now I can't watch YouTube on my phone. All of this ridiculousness is getting to be a lot. It's a lot. All right, let's find that letter. I was under the impression that this was supposed to be at noon. Do I have the wrong time? Do they think we can, just sit here all day? I guess they do. We got nothing else to do, right? We got nothing else to do. Good evening to everyone except Brennan. Well done. Well, when it's time, we'll be there. But until then, oops. Tom still sees them in the hallway. All right, you guys are good. You guys are good with your updates. Thank you, Double Bandit Leather Company, for being my volunteer tech squad. You may have to increase the quality of your feed with the new phone. Bump it up from 720p. I don't know. I got the iPhone 16 Pro Max. Go me. Maybe that's what I need to do. Thank you. They aren't even in the courtroom yet. Okay. So let us take a listen to the latest letter from Mark Bederow to Judge Helena Rafferty. And it has to do with these exact charges that we're here for today. So I will try to read it to you in my best ASMR voice. For those of you who like that sort of thing. It's not your phone, it's YouTube resetting your video quality. Oh, all right. How do I fix it? I don't know. I'm not like really technologically advanced. I'm kind of technologically challenged. I don't know. There's got to be something to do in the settings. Okay, here you go. This is a Bederow letter dated March 10th of 2025 to Chief. Oh, it started.
I'm told the judge because obviously it's a complaint.
Hello, Kamala. My wife wants to think went to the area, but
There's not really much audio yet.
No, I was.
I don't know who JR is, but he might want to turn off his video. He's not actively participating. Okay. Okay, Tammy. Thank you. We may have to modulate the sound. But we'll see how low the audio is, and then I'll turn mine down if we need to.
We got people sit over here as well, okay? I don't want anybody
I'm sorry?
standing, so try to make some room for everybody, please. You have to squeeze in. I don't want anyone standing.
Yeah, this is Stoughton District Court. So it is a different courthouse. It is a different courtroom. It is small. iPhone 16 got issues. It's been driving me nuts. Oh, great. Maybe that's why I got a deal on it. Do we know the judge's name? I don't, but it says Monica Collins. We're in Monica Collins' Zoom room. But does the iPhone 16 Pro Max butt dial? Nope. Is Monica Collins a judge in Stoughton, or is this like... It says, when I look up LinkedIn, it says she's a consultant, so I don't know if she's a judge. Well, she's a clerk magistrate, assistant clerk magistrate for the executive office of the trial court. That's Monica Collins, so maybe it's just her Zoom room. I don't know. Lots of trolls here today? Oh, all right. I'll change the settings. Thanks for telling me. Bye-bye. Big old dog says we're about to see how bad Massachusetts is. Scott McGinnis says state police CAT followed us over to Stoughton Court from Dedham. Are you shocked, Scott? Are you shocked? Romy gifted 10 memberships. Oh, Romy, I love you with all of my heart. And final see you soon. I'm gonna die. 13 King says, thank you, Romy. That was really super generous. Chris Albert needs to be brought up on charges. We were just about to read that Bederow letter. Janet McGee says, thank you, Melanie. Loved your comment to Will and Turtleboy that you would have grabbed them by the ears and pulled them away from DNA. Listen, friends don't let friends catch charges. Just don't. You gotta be wicked smart. You gotta be wicked smart, okay? When everybody's out to get you, you gotta be wicked smart, you know? It's just, you know. Diane is praying this charge will be dismissed. We don't know. It's like they spun the wheel. I think the judge has, yeah, I know the Trex arms. It was kind of funny, but again, you know, like I think I've seen this film before, and I didn't like the ending. Don't get mad about my Taylor Swift references because it's true. We've seen this film before. We didn't like the. Here they come.
Court in session, you may be seated. Good afternoon, Your Honor. In the matter of AIDAN Kearney.
I'm turning my volume way down. So turn yours up.
Mr. Kearney is before the court on docket 25 CR 225, being charged with one count of intimidation of a witness or a police court official on March 5th, 2025 in the town of Canton. The defendant has filed a motion to dismiss. Commonwealth filed a motion to revoke the defendant's bail, and there is an email for you.
Just give me one moment to look at the email. And just to be clear for the record, there was a video that both counsel submitted. I've marked it as Exhibit 1. It's in the court's file. I viewed that prior to coming out.
Thank you, Your Honor. No objection to that.
Thank you.
Timothy Bradl on behalf of Mr. Kearney. Good afternoon, Your Honor.
Good afternoon, Attorney Bradl.
Good afternoon, Your Honor. I'm Robert Cosgrove, Special Assistant District Attorney for the Commonwealth.
Good afternoon.
That's relative to the bail revocation issue, Your Honor.
Okay. So, do you want to hear the motion to dismiss prior?
In light of the Commonwealth's position, I would certainly ask for that, Your Honor. Thank
All right, I'll hear you.
you very much, Your Honor. Your Honor, the Stoughton Court, I just want to start with this court. The Stoughton Court has a interesting relationship with the witness intimidation statute and me and Mr. Kearney and some other clients I've had. There's been about 5 or 6 cases that have come through here where this exact type of conduct at issue in this case has been not acted upon by the court. Judge Walsh in this court, in a case called Commonwealth versus Richard Schiffer, same kind of thing. This Canton police did a 37-page investigation of Mr. Schiffer leaving rubber ducks around Canton with political messages on them relative to another prosecution that you're probably aware of, the Karen Reed murder case. And the Judge Walsh dismissed it at arraignment for violating the First Amendment. Assistant Clerk James Flanagan in this court, I represented four women that were accused of the similar things, sending out messages, commenting on the case directly to witnesses, leaving ducks around Canton. All 4 of them were not acted upon. There was another instance of what's called the Canton 9, Your Honor. People that were demonstrating in the middle of Canton. There were 9 people were charged with witness intimidation and other related charges, all dismissed. So the Commonwealth just doesn't get it, Your Honor. We need a seminar on the First Amendment. And here we go again. We have Mr. Kearney in this case, Your Honor, is exactly where he's absolutely entitled to be. There's no stay-away orders in place. There's no restraining orders. There's nothing that prohibits Mr. Kearney from going down that street. He went to Jeff McCarthy's for a meal, and he walked by the complainant Albert's Pizza Place in Canton. He looked inside. He saw a camera inside, and looked at it and looked in there and spoke to no one, to a glass window at 9:30, 10:30 at night, 2 occasions before and after. So he had every right to say what he did. The only involvement that the court needs to be concerned about would be if he uttered threats or fighting words. That's already been roundly established in my 14-page memorandum, Your Honor. I'm not going to belabor it. I know you've read it. I appreciate you having that. And the cases are all there, absolutely spot on point, Your Honor. All these issues have been covered. There's no threats here. There's no fighting words. There's nothing that is criminally actionable that happened whatsoever. Because the Commonwealth doesn't like it, they want to use it as probably their 10th or 11th, what I hope will be their failed excuse to try to go after Mr. Kearney. Not because he's a danger to anyone, not because he's doing anything criminal, but to silence his speech. That's what this is about. And that's why I've been so happy to always be coming to the Stoughton Court on these cases, because the Stoughton Court gets it. The Stoughton Court looks at these cases and says, this is not a crime. Stoughton Court has, with an unblemished record, Your Honor, upheld the First Amendment. And I hope that in this case, which is just as weak, if not weaker, than all the other things they're trying to say are felonious activity, I hope the court will address it appropriately, and I know the court will. So in terms of whether the court ought to, whether the Commonwealth rather, ought to be permitted to bring this forward, there's absolutely no basis. Everything that Mr. Kearney said is not actionable. There's no threat, there's no fighting words. The only reason, Your Honor, that this has been given life, Your Honor, is because of the complainant's illegal wiretapping. He had a camera inside the store that apparently picked up sound. And also, Your Honor, there was a camera in the top right outside on the street that picked up the sound of every person walking by. So there's no warning signs, there's no notice that someone is being intercepted under 272 Section 99, the wiretap statute. He's been committing a felony every time someone's voice gets picked up on the street, and there's no warnings about it whatsoever. So Mr. Kearney doesn't have to, when he's clowning around outside the store where he's absolutely allowed to be. And incidentally, Judge, the last time we were all together in Superior Court, Mr. Kearney agreed under Section 87 to a stay-away order on this situation. So that speaks well of his understanding that he's not going to risk any other problems or issues. So that's on the side, if I may, Your Honor, that this has been agreed to when the government brought the bail request that they told me they were going to be renewing here. We agreed to it. So I want the court to be aware of that as well. But in terms of this speech, Your Honor, the only reason that the complainant heard this speech is because he was illegally wiretapping Mr. Kearney. This never would have come to life. He never intended it to come to life. He didn't know it was going to come to life. And the next thing you know, he's being wiretapped by the complainant, who now wants to use his illegal behavior to try to get Mr. Kearney locked up. The whole thing is a complete absurdity, Your Honor. Mr. Kearney is talking for the benefit of his friends to a window on a almost empty street at 10:30 at night. There's no danger whatsoever. There's no basis to plug that conduct into the many elements of witness intimidation to try to concoct some bizarre alchemy, some felonious charge that would somehow get past the First Amendment for all the reasons that I stated in my motion, Your Honor. So that's what I have for the court. I appreciate you reading my motion, and I'm asking for about the 10th or 11th time that the court dismiss these charges. Thank you.
Okay, that was Bradl.
Thank you, Your Honor.
Motion to dismiss. Cosgrove
Mr. Albert,
moves bail.
as is his son, is a witness in the Karen Reed case. Mr. Kearney has been in the process of conducting a campaign against virtually every Commonwealth witness in the Karen Reed case, using his various media outlets. What I would like to do is briefly read the court some excerpts so I can put them on record from the police report of Lieutenant Tully. Some of it characterizes the video that Your Honor has already viewed, but it's also illuminative of the reaction of the Alberts upon viewing that video. After I do that, Your Honor, I will proceed to address the contentions that have just been raised by Mr. Bradl. Lieutenant Tully indicates that on March 5th, he spoke with Chris Albert, and he mentions that the Reed defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings in an open court that Colin Albert, who is Chris Albert's son, is responsible for the death of John O'Keefe and that Chris Albert has aided in the conspiracy. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and their friends. He authors and publishes a blog on the website Turtleboy Daily News. The website has a series of articles entitled Canton Cover-Up. He goes on to describe arresting Mr. Kearney on charges he was later indicted with. Those indictments are still pending in Norfolk Superior Court. Chris and Colin Albert are named victims in those open cases. Chris Albert forwarded to Lieutenant Tully 2 videos from March 4th of 2025. Subsequent to that, Your Honor, the district attorney's office merged those 2 videos, so the video that you saw shows the 2 of them playing simultaneously. They're 2 different cameras showing the same events. The sound has also been enhanced, but otherwise the videos are in no way changed. As described by Lieutenant Tully, the video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is a bar/restaurant located next to D&E Pizza at 614 Washington Street in Canton. The group is seen leaving McCarthy's that joins Kearney Kearney stops in front of D&E and places his face next to the glass window. Interior camera catches him standing close to the glass, staring at the camera for approximately 25 seconds. Male with the group that exited joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. Audio is captured by an exterior camera. The sound of the occasional passing motor vehicle obscures the audio. Lieutenant Tully stated that he could discern the following statements made by Mr. Kearney. Hi, Chris. What have you done? Murdered, then goes inaudible. Misses you. Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home? Why did you say you went upstairs and then waited 15 minutes? And Colin came home. Colin didn't make it home until at least 12:45. Chris, it was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands to herself, too. The statements made by Kearney and his conduct of standing outside D&E Pizza is similar to the conduct that was the basis for his prior indictments. Kearney directed his statements into a camera that he knew would at least be seen by Chris Albert, a named victim in the pending witness intimidation case and a witness in Commonwealth versus Reed. When Chris saw the video shortly after the incident, he became upset. He stated he is upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him or his son, which I would add, as he has done in the past. Subsequent to that, and as Mr. Bradl indicated, I brought this conduct to the attention of the Superior Court at a hearing on Mr. Bradl's motion to dismiss about 2 weeks ago. Lieutenant Tully received another video, and I want to add, with respect to the first one, that what brought this Chris Albert's attention was that on March 4th, he received a phone call from his son, Colin, who was working at a pizza restaurant that he owned. Colin learned that Kearney was having dinner at the restaurant next door. He was very unnerved and anxious about Kearney being next door while Colin was working. Chris, who was attending a Canton Select Board meeting, traveled to D&E following the meeting, and they closed the pizza restaurant at 9:30 and went home. He then received an alert on his cell phone from the camera system at D&E Pizza, accessed the video recordings, which Your Honor has viewed. Chris was very upset about Kearney's statements into the video camera, especially given previous incidents where Kearney picketed outside the restaurant during business hours. He's also very concerned Kearney will continue to be outside the restaurant and will confront him, members of his family, or patrons in a similar manner Kearney has done in the past. And I think the second video that Your Honor saw was a later discovered video indicating that Mr. Kearney had been present earlier in the evening. Now, with respect to the motion to dismiss, if I can turn to that in this point. I don't have a quarrel generally with the proposition the First Amendment protects a wide range of free speech, and that the usual remedy for a victim of defamation is on the civil side of things and not on the criminal side. But what the defendant ignores, and I believe Mr. Bradl ignores, is the courts from the U.S. Supreme Court on down have said, where the Commonwealth or the state has a compelling interest, it can craft an appropriate limited criminal sanction regulating speech in a reasonable fashion as to time, place, and manner. Now, there are a number of examples of that in our law, Your Honor. I'm sure Your Honor has probably had occasion to issue 209A orders. A typical feature of those orders is that the 209A recipient is to have no contact, direct or indirect, with the victim. And the cases have uniformly supported that when that contact is made, whether it's a phone call, we might otherwise say is freedom of speech, even if it's an innocuous subject matter, even if the defendant sends the recipient of the 209A order, the protected person in the 209A order, a bouquet of flowers, that is a violation that may be criminally punished. We also know that laws protecting courthouses and prohibiting disruptions outside of courthouses are also constitutional and legal. We also know that judges routinely impose conditions of probation, requiring no contact, stay away, not travel in a certain area. Those orders, too, Your Honor, arguably impinge on rights of free association and speech, yet all of those are constitutional and have been upheld. With respect to the victim witness intimidation statute, which is at issue here, the legislature has imposed a very limited restriction on speech. And the limitation comes in the form of two elements. One is the protected class is not the public generally. They are left to their civil remedy. But the protected class are witnesses in a criminal case. The second reasonable limitation, the second restriction, Your Honor, is that to prove witness intimidation, the Commonwealth must prove beyond a reasonable doubt the specific intent of the defendant's conduct was to intimidate the witness. Now, it seems to me, Your Honor, that one of two things has to be true. Either 209A orders, probation conditions, and laws against disrupting court proceedings are unconstitutional under the First Amendment, possibly other amendments as well, as is the witness intimidation statute. Or the witness intimidation statute constitutes a reasonable limitation by the legislature in service of a compelling state interest, which is the integrity of the criminal justice system. Mr. Kearney has effectively conducted a campaign against virtually every Commonwealth witness in this case. It has been unrelenting. I don't know if I am to go back to those witnesses, those victims, and say, well, you have a civil remedy, go over to civil court, file a lawsuit, hire an attorney if you can find one, retain him for $1,000 or $20,000 or $50,000, or maybe you can get a contingency fee. And then after depositions and motions and interrogatories and so forth, 3 or 4 years from now, you might recover a nice civil judgment. But in the meantime, every day you are going to be hammered and intimidated, and there is nothing the criminal justice system can do about it. Those seem to me, Your Honor, to be the alternatives. And based on that, Your Honor, I would ask you to deny the motion to dismiss.
I have a couple of answers.
Briefly.
Judge, page 5 of my brief, U.S. v. Alvarez, sets out the entire field of where the government can intrude on the First Amendment. There's no provision for reasonable restrictions on this or that. There's no opportunity for the Commonwealth of Massachusetts to try to criminalize civil tort law somehow.
I don't think that's what Attorney Cosgrove was saying. I think what he was saying is that it's a different class than the general public. And while I agree with your sentiments regarding Alvarez and the general public, what we're talking about is a more restricted class, specifically witnesses in a criminal proceeding or possible witnesses in a criminal proceeding, and in this case, a known witness in a criminal proceeding.
There's one other issue there, though, which is that there's no stay away order. There's not even a stay away order.
And that's
That's the determining factor.
well, that may be the determining factor at the end of the day with respect to a defense at trial, or perhaps whether or not his conduct was harassing as the statute anticipates. But the standard of proof that I need to apply here is whether or not there's probable cause that he's violated the statute. And a statute that reads that did mislead, intimidate, or harass another person who was a witness or potential witness.
Yes.
And
Can I address that point?
sure.
Thank you. I appreciate you letting me jump in. Harassment is defined, and harassment is limited by O'Brien v. Borowski, true threats, fighting words. So manifestly, these videos have no threats, no fighting words.
Wait, so take the sound out of it. The video that I watched that you both submitted by agreement begins with him just staring directly in the camera. He's not passing by. He walks to the camera and then he walks back in the direction from whence he came. And he's staring at the camera for a prolonged period of time before another individual comes up and starts speaking to him, and that's when the words happen. And whether or not you have a Fifth Amendment claim for the witness at trial because of wiretapping or not, it's not what's before me. What's before me is whether or not there's probable cause to support the charge. And after considering your motion and the depths of research you've done on the First Amendment, and considering the standard of proof that I need to apply here, which is probable cause, I'm going to deny the motion to dismiss.
Please don't my objection. Thank you very much.
Your objection is certainly noted.
Welcome to the upside down. Let's see what he rules on the motion about revoking the bail.
Commonwealth, I hear you on your motion and any request for bail.
Thank you, Your Honor. With request to bail on this case, Your Honor.
Does Mr. Kearney be arraigned first?
He was arraigned. Right, you entered pleas of not guilty. He was arraigned. I mean, I would have stricken the arraignment had I allowed the motion to dismiss. That's why I wanted to address it first.
Thank you, I appreciate it.
With respect to the question of bail, Your Honor, I'm going to request that the court set bail in the amount of $5,000 cash on the instant case, and I'm going to ask the court to impose a stay-away order from Mr. Albert and any member of his family. And I'm going to ask that that order, I should say a no contact order, direct or indirect. And I'm going to ask as well that the court order that Mr. Kearney remain away from the pizza shop, from the home of any of the Alberts, and from any place of work of the Alberts, and that he maintain a distance of at least 100 yards from those locations. The order in the Superior Court, I will say, is a little broader. The order entered the other day, and it now extends to all of the witnesses in this case, but since only the Alberts are implicated in the case before Your Honor, I think it's proper to limit the order here to them.
In the motion to revoke?
Yes. With respect to the motion to revoke, Your Honor, I think it's important to consider that this is the same conduct, or another species of the same conduct, for which indictments are pending against the defendant in the Superior Court. There are indictments for intimidation of a witness with respect to Brian Albert, with respect to Christopher Albert, and with respect to Olin Albert. These indictments represent a series of conduct by Mr. Kearney, including showing up at selectmen's meetings where Chris Albert is a selectman. In one meeting, Chris Albert testified before the grand jury that at that meeting, Mr. Kearney came within 2 feet of his ear, holding negative signs about him, stuck his middle finger in his face, captured on camera for his viewers, and as he left the building, he and a mob of about 15 or 20 people pursued him to his car, screaming at him, calling him and his son a murderer. When Chris reached his car, Kearney and his followers surrounded it and prevented him from leaving until the police were able to back up the crowd. He's encouraged people to harass Mr. Albert at his business. He's run videos attacking members of the Albert family, including Mr. Albert's wife. I'll read you some of the titles of those, Your Honor, that were played for the grand jury. Episode 590, Call to Julie Albert. Julie Albert, I might add, has nothing to do with the Reed case, but in Mr. Kearney's view, she's a fair target because she's related to somebody who is. Therefore, to attack her is another way of putting pressure on and intimidating a witness. Episode 598, Life as Normal is Over. Time to hit the gas. No right for Chris Albert to live peacefully. Albert should be afraid. Kearney outside D&E Pizza. And those, Your Honor, were examples of some of Mr. Kearney's shows prior to the indictment. Indictment has not fazed him, Your Honor. He's continued to harass the Alberts and the other witnesses. When you look at the videos in this case, if you looked at them in isolation, if I looked at them in isolation as a prosecutor, I might think, oh, well, there's maybe a few sheets to the wind after his visit next door. He's clowning around. It's fairly innocuous, repulsive, but innocuous. But understandably, the Alberts and the Commonwealth look at them in the context of the prior conduct. This conduct has continued since his indictment, not only with respect to the Alberts, but as to the other witnesses. If Your Honor has viewed the exhibit submitted by Mr. Bradl, I had some discussion with him about what I would be asking for today. And I didn't indicate, quite candidly, that I was going to move to revoke Mr. Kearney's bail. That was not my original intention. But I did say subject to, I don't recall the exact language, but Your Honor has it in front of him, subject to what may go on between now and then. Shortly thereafter, I discovered that Mr. Kearney had gone on one of his YouTube presentations and encouraged every resident of the town of Canton to file illegal wiretapping complaints against Mr. Albert. Now, I'd be the last person to say that citizens should not contact police departments if they think there's been a violation of the law. But one of Mr. Kearney's attorneys, Mr. Bederow, had already sent a letter, which I suggest was retaliatory in intent, to the Canton Police Department, claiming that Mr. Kearney was illegally wiretapped. Well, the Canton Police can do with that whatever the Canton Police are going to do with that. I think it would be improper for me as a person charged with prosecuting, as a special prosecutor charged with Mr. Kearney, to even express an opinion to the Canton Police Department. I have my own opinion of the merits of the complaint filed by Mr. Bederow. But that having been filed, Your Honor, what possible purpose does it serve for Mr. Kearney to encourage every citizen of the town of Canton to go and file complaints? And I suggest it serves no purpose but to harass Mr. Albert. I would also suggest that it is difficult to look at that video and think anything but that Mr. Kearney clearly saw the video camera, which was visible in the window, and wanted that video recording to be seen and, if possible, heard by Mr. Albert. I think one of the things that may be concluded by the Canton Police, and I don't want to get too far out in front of my skis, is that the illegal wiretapping statute requires that there be secretive video. And when a video camera is clearly visible in front of a store, I would suggest that's not secretive and therefore it's not illegal wiretapping. But if it is, I think when the Canton Police act against Mr. Albert, they can then do a survey of the whole town and possibly bring charges against everyone who has one of those doorbell videos. That said, Your Honor, it was still not my intention to move to revoke Mr. Kearney's bail. But then I became aware just a day or two ago, and I only became aware of this yesterday afternoon, Your Honor. Mr. Kearney, on his show, engaged in about a 10 or 15-minute vile attack on Elizabeth Proctor, describing graphically her giving oral sex to her husband and other such comments. Elizabeth Proctor has nothing to do with the Karen Reed case, except that she is the wife of a police officer involved in the investigation and a witness in the case, and therefore fair game for Mr. Kearney. And I mention this in particular, Your Honor, because one of the things that I understand the Commonwealth needs to show is that no order entered by the court is likely to be effective in eliminating the threat to the public, or in this case, the threat to witnesses in the Karen Reed case and in the Kearney case, and I would suggest the threat to the fair and objective administration of justice. I think that Mr. Kearney, by his conduct, has amply proved the court he is going to keep going with his intimidating conduct as long as he is free. And therefore, I ask the court to revoke his bail.
Attorney Bradl.
Your Honor, Commonwealth uses the word retaliatory. This entire bait and switch the Commonwealth has perpetrated on me and Mr. Kearney is the only thing that's retaliatory here. On Friday, counsel emailed me with respect to the bail issue here today. I said to him that I had, at the time, 2 other cases today. I actually have 3 other cases today. But I don't have time on that date, meaning today, to do what we've been doing here for however long. That if we're going to have a quick bail hearing where the issue is how much money and stay-away orders that we've already agreed to in front of Judge Doolin in Superior Court, that's what I expected today. And I've never, in 32 years of practicing law, had a prosecutor or seen another prosecutor when I was a prosecutor say to me, yeah, come on in, we'll get this done quick, everything's going to be fine, and then come into court 5 minutes before coming before Your Honor and say, no, we're going to revoke his bail. Oh, really? Why? Because he said something nasty about somebody. And here's the kicker, Your Honor. In a private show that people have to pay to hear, not in public, to a private audience that somehow got leaked out to whomever. And that show was Thursday night before the Commonwealth committed to a normal bail hearing where there was a very minimal issue at stake. And now the Commonwealth wants to come in here on 5 minutes notice to me and change it up because of this pretextual excuse about something he said that is non-criminal, non-actionable, that he doesn't like in a private setting. That's what's retaliatory, Your Honor.
Well, perhaps I can short circuit all of this.
Please do. Thank you.
Wasn't this addressed in front of the Superior Court? This conduct was addressed?
It was, Your Honor.
So I think under my reading of the bail statute, Mass General Laws, Chapter 276, Section 58B, that the motion to revoke has to be brought at the first appearance in court. It doesn't say which court, his first appearance in court. If he got arrested in Chelsea, this hearing would be happening in Chelsea at the moment of his arrest. And so the idea that this was addressed in front of the court who's hearing the case on which the Commonwealth seeks to revoke, and there were conditions placed as opposed to bail being revoked at that point in time, I think was the first appearance. And I'm procedurally denying the motion to revoke bail because I don't think it's properly before this court.
Wow.
In that
He's
case,
very
we would
lucky.
agree under Section 87, Your Honor, to the stay-away orders requested.
What about the cash bail request?
And Judge, in terms of a cash bail, Mr. Kearney's got no record. He's been to every court appearance. We talk, 10 times a week. He has 2 kids, lives in Holden. He's a former school teacher who has shows that he does every single night. I don't know of anybody who has more roots in here that's not going to cause any sort of a flight risk. So I would ask that you forego a cash bail, Your Honor. And he's absolutely willing to just make it a Section 87 agreed on bail condition relative to stay away orders. And we ask that you allow that and allow him to appear on his personal recognizance.
So after hearing on bail, I'm going to release the defendant on personal recognizance with the following conditions. Stay away, no contact, no abuse of the Alberts, remain 100 yards away from the pizza shop and any other workplace, stay 100 yards away from their residences. That's with the consent of the defendant.
Correct, Your Honor.
I gotta say, I'm surprised. He didn't sound like he was gonna go that way.
May 15th, Your Honor.
That's fine. Oh, wait, was that one of the dates that was not a good date? Okay. May 15th is fine.
So you're going to be released with conditions for your parents back here May 15th for a pretrial hearing. Conditions are that you have no contact directly or indirectly with any of the Alberts and family members, that you remain 100 yards away from the pizza shop and any place of business in the home of the Alberts. Failing to comply with those conditions or picking up any new charges during the pendency of this case, you could be held up to 90 days without bail. That's your bail warning. You'll need to check in with probation. Before you leave the courthouse today, you'll need to sign those conditions of release. Commonwealth's motion to revoke your bail has been denied. The motion to dismiss has been denied. You're all set, sir.
Attorney Bradl, just to be perfectly clear for the record, the defendant consents to these conditions I've checked off under 87 that these are, okay.
Thank you.
All right, thank you.
Thank you.
No, that's all we have.
Court, all right.
Give it a second.
Yeah, no, yeah.
I'm shocked. I gotta say, I'm shocked. Okay, everyone, readjust your volume. Turn your volume down so that I can turn my volume back to normal. And we can get back to, all right, now my volume is where it's gonna be. Hopefully I didn't blow your ears out and gave you enough warning. Okay. This is, I'm shocked. I'm shocked. I thought he was gonna revoke his bail. First, I thought he was gonna dismiss the charges, but then he didn't dismiss the charges. That was denied. And then I thought perhaps he was going to revoke his bail. My emotions are all over the place because I had no idea what he's going to do. But please, please, AIDAN Kearney, for the love of God, take a step back for just a little while. They want to get you back in jail. They want you on jail, and they will stop at nothing to put you back there. So just please, please, please try. I know it's hard. I know it's hard. I know this is how you make your living. I get it. But really, please just try. They will do everything that they can. You really dodged a bullet today, but from now on, please, I'm saying this to you as as somebody who likes you personally. You're very nice to me. You've always been very nice to me. I'm just saying, as a friend, just like just please try to stay out of the line of fire, because they will stop at nothing. You know that. You're smart enough to know that. Let's just, all right, they're going to come out the courthouse now. So we're going to flip over and see if we can see Tom CPU. Watch them come out. Maybe they'll do a statement on the courthouse steps. Tom is always cool about letting me play his stream. So we're going to, Flip over there. I'm just gonna hit mute people. If and when they come out of the courthouse to make a statement, that was like on the edge of your seat kind of thing. I mean, I really had no idea what that judge was gonna do. I don't know his name. We've never seen a hearing with him before, so it was interesting. He didn't even make him post a $5,000 cash bail that Cosgrove asked for. And a lot of you, I heard a lot of the chat saying, you know, and all of this stuff, all of this stuff is old. It doesn't matter all the stuff he did before. It does. If it goes to a pattern of conduct and a pattern that the judge believes cannot be stopped without revoking his bail, all of that stuff was relevant as far as potentially revoking his bail. So all of the prior acts and all of the prior bad acts were relevant to that issue of potentially revoking his bail. And he's very, very lucky that didn't happen today. And even he thought that the potential was very high that they could revoke his bail and put him back in jail. And I think that that's probably the last place that he wants to be, because if he's in jail, he absolutely positively will not be able to make a living. So there's that. If they come out, we have the ability to pause and rewind. So just let me thank Tracy Walker for gifting 10 memberships. You're awesome. BC says, I almost always sing the intro song, but now my toddler is dancing with me. I love that. I love that. And I think we addressed some of these before. Mr. and Mrs. Smith with another 50. We moved to another her matter. I don't know what that means. Another matter? You mean for your trial case? Watching the OnlyFans says, Brina gets up and misrepresents and takes partial statements from Karen. Can the defense introduce the full context without her getting on the stand? Yes, possibly, if they get all of those outtakes from the Discovery ID documentary. I think that is what you are referring to. Clara is here and is thanking me. Thank you for your 10. Everyone, make sure that you smash that like button. I promise you, MSP will not get your DNA. And it also is the nice thing to do. Even if you're hate watching, hit the down like button because, you know, engagement, right? Thank you, Clara, for watching from Tennessee. Free Count Read and Free Turtleboy, she says. Al Dente, did you see Courtney Proctor News 5 last night? Sorry if you already mentioned it. She did a Freudian slip. I did not catch that. So I do have it pulled up somewhere. Maybe we can watch it. KMAX says, Hank stating that pathologists only work on dead people is wild. Pathology is used every day in medicine. He states everything as a fact. He does, and he's often wrong. We point it out every single time. Including his mispronunciation of coup contra coup. And he called it counter coup. Liz Reed is here. Always glad to see you too, Liz Reed. Thank you so much for coming in and watching. Appreciate your super chat. Gina G is here. Belated St. Pat's. Thank you for teaching us on this case. All right, here he comes. Hang on.
Thank you, guys. Love you guys, man.
Oh, the volume.
We love you. You're going home.
That was close. That was nerve-wracking. Thank you guys so much for being there. How much fun was that? Not fun at all. It's the worst time just to have somebody try to, you know, like I said, we got an email from him on Friday saying bail revocation's off the table. And then we get here today and I find out 5 minutes before going in there, it's actually on the table. He just lied. He's a snake and he's dishonest and he lied. And, you know, luckily the judge, I mean, on the technicality, it seems, decided not to revoke my bail. We had a much larger argument than the one that we made. We were ready to prepare because there's no reason to legally revoke my bail anyway. But, you know, we got up on the technicality. So, but, you know, I'm just so grateful, man, to be going home. You have no idea. Like how. Let's go to the McCarthy. Ever again. Is it going to affect the Karen retrial at all? Oh, no, I don't think this will affect Karen's trial at all. I mean, this is just, other than the fact that they try to sully up her reputation with my charges. That's all. They try to take my charges and say she talks to him, so she's bad too. That's the whole purpose of these charges is to begin with, is to sully Karen Reed's reputation and make it harder for me to, you know, activate and get people. And you guys heard him today. He said that I urged people to report wiretapping to the police. First of all, I didn't urge anyone to do that. Secondly, Who cares if I did? You're allowed. If you feel like you're a victim of a crime, you have every right to go to the police. Since when
Absolutely.
did that become harassment? To go to the police and say, my rights are being violated, a crime has been committed against me. And we had the audacity to bring that up today as if there was something wrong with that. No, there's something wrong with what they're doing. And
Also, the board meeting where they're trying to say that you told people to stand in front of his car.
that never
That you
happened.
can't control grown adults.
Video shows
So,
all like
What people do is what people do. You have nothing to do with that.
yeah, I mean, it's hard when somebody gets up there and just lying about you, lying about the
Absolutely.
things that you're saying,
Absolutely.
lying about the things I said in that video. It's just lying. It's just hard. It's hard to hear it, you know,
To wait your turn.
and hard to know that like he's doing this because he wants you to go to jail for 60 days or whatever. And it's like, he doesn't care about the other people that this affects, my kids, you know, my family. There's a lot of people that are affected by incarceration. Yeah, you guys, obviously you guys too, you know, like, but so I'm just so happy, man, to be going home. You have no idea.
Well, your voice stands up for all of our voices too.
And how awesome is Tim Bradl?
Is the Commonwealth a paid member?
Apparently, I guess he's subscribed. I mean, the thing about that is he sent that email on Friday saying, if anything happens, I'm not going to revoke bail unless something happens between now and then. Well, that happened before. Like this video was Thursday the night before, and he claims he got it sent to him yesterday. I wonder by who. I don't think Cosgrove subscribes to Turtle Club. I don't think he's technical enough to figure out how to log in. He probably, you know, on his iPhone. And so I mean, somebody sent it all because we all know that there's no shortage of people out there looking to take things I said out of context, send it to Cosgrove because this is all just a game to them. That's all this is. Fun and games to try to, you know, put somebody in jail for something that they obviously didn't, you know, do. So
He's behind a paywall though. How's that work?
All you have in this business is your word.
Yeah.
You know, we had an explicit conversation about it, and I'm just shocked that he would do something like that. I mean, you don't do that. You don't forget something like that. So I'm really disappointed, shocked, outraged. It's unbelievable.
Get him.
I mean, I am so sick of defending this guy over speech. Give me a break.
Well, you're good, they're
Words
evil, and
they
you're
don't
gonna
like.
try them.
Don't forget, we're the good guys. We're the good
That's
guys.
right.
This is complete BS. It's another one of these circumstances where they just unabashedly come into court and say, we don't like what he's saying, so judge, lock him up. It's so brazen. It's so un-American. It's horrifying. And we need more people like you guys to step up. Where's the media? Where's the journalists that are next?
He's in court.
When they're done, where, you know, the mainstream people, right? You know, we're all here.
they're giving softball
But,
interviews
you know,
to Elizabeth Proctor.
Oh, God.
When they're done with him and me, who's next?
Right.
Where's that person?
Right.
Well, thank God we got you guys.
You guys, thank God I have you guys. Thank you so much for coming.
Yes, that makes it.
Yeah. Love you guys so much,
Guys
man.
like
Thank you
that.
guys so much.
Guys like that.
All right. We'll see you soon. Tomorrow night. Back in business.
All right, you can adjust your volume now back to normal. He said, I'll see you tonight. So I guess he's talking about a show. So I don't think that there's a 2:00 hearing. I don't know who thought there was a 2:00 hearing. Yeah, look, free speech and all that. And I agree with a lot of you in the chat who there's a strong disagreement here between, seems like the chat might be evenly divided. Like a lot of you are saying, like, just no comment, go home, it's enough. And a lot of you are like, free speech, don't tell them to stop talking. In my opinion, they're not going to stop until they get him back in jail. And I'm not saying he doesn't have a right to speak or that what he's saying is perfectly acceptable under the First Amendment. What I'm here to tell you is that Norfolk County and some of the judges there do not seem to understand what the First Amendment means. And so it may be in your best interests to sort of just take a step back and try and refrain anyway, so that you can keep the privileges that you currently have of, you know, going into the courtroom. Right now, he hasn't been banned from the courtroom. They're trying to ban him from the courtroom by putting him on the witness list. they're going to have to make a motion to let him have a special dispensation like they did for Gretchen Voss during the first trial. And I don't know if the stay away order that was just granted, where he's got to stay 100 yards away from the Alberts, Chris Albert and Colin Albert, because apparently nobody told Cosgrove how to pronounce Colin. And he's pronouncing it like Colin Powell, I guess spells his name Colin, but pronounces it Colin. And so the 100-yard stay away order from both the places of work and from them personally, will that prevent him from being allowed in the courtroom during the days when Colin Albert and Chris Albert are there and Julie Albert? And also, if the judge does agree to allow him into the courtroom for the trial based on the fact that she gave Gretchen Voss a special dispensation, like, the Pope. And so for those of you who are just tuning in, this was in Stoughton District Court. This was an arraignment on the charges that occurred from, I don't remember the exact date of when this happened. Do you guys remember? Was it the 5th of March when it was the same? I don't know. Glare was in town. Nan Gallagher was in town. Turtleboy and Meredith, they were all at CF McCarthy's. They came out of CF McCarthy's. They admitted they were all drinking and a little bit, maybe buzzed. And according to Cosgrove and the judge, AIDAN then went over to the window of D&E Pizza, stared right into the camera for 25 seconds, which the judge seemed to think was intimidating. And then he was captured on audio from another camera that was also outside D&E Pizza, which may or may not be illegal wiretapping under the laws of the state of Massachusetts. But again, the judge is not considering that for purposes of whether this particular incident of alleged witness intimidation and witness harassment and intimidation would be dismissed. Bradl argued for a dismissal. It was the dismissal was denied. So he was arraigned. He was arraigned initially when he went in, pled not guilty. Bradl argued the motion to dismiss these charges by saying, "Judge, there were no fighting words. There were no fighting words. There were no threats. He said some things to the camera. It was picked up by another camera. Illegal wiretapping. Chris Albert is doing things that are against the law by illegally wiretapping everyone on the sidewalk in front of D&E Pizza. No threats or fighting words." And he said, "I like it here because the Stoughton Court gets it," Bradl said. And then he said that they already agreed to a stay away order when they were in front of Judge Doolin. And so you shouldn't need to grant one because we already agreed to one. And so therefore, the judge said, "But that's not why we're here. We're here to determine whether or not there's probable cause to determine that he violated the statute under the law." And so the judge said he was staring at the camera for however long, 25 seconds, 2 minutes. I don't really remember how long. And so he says, there is probable cause to bring these charges. Motion to dismiss is denied. And then Cosgrove got up and argued bail. And his first argument was you should order a $5,000 cash bail and a stay away order and a no contact order of 100 yards of all the Alberts, or Chris and Colin, I guess. And then at one point, didn't he say that Colin was inside the pizzeria when this happened? That was a little bit muddled for me. The sound was so awful. So I hope you guys were able to hear it anyway. And then the judge said, "Okay, what about your motion to revoke bail?" And then Bradl was like, "Wait a second. He told me that he wasn't going to make a motion to revoke the bail because we didn't have enough time on this because I'm really busy and I have a bunch of hearings." And so Cosgrove argued it anyway. And he brought in all other examples of times that he says that AIDAN Kearney and his prior conduct, and he has a pattern and habit and custom of intimidating witnesses in the Karen Reed trial, and that there are all these other felony charges already pending against him. And that he actually says that on Thursday night, he did a show on his YouTube channel, a YouTube presentation. He called it a YouTube presentation. Cosgrove argued and said that he encouraged his viewers to file illegal wiretapping charges against Chris Albert, and that shows that he's not taking this seriously and you should revoke his bail. And he also said that, I don't know if that was the same Thursday night show, that there was a Thursday night YouTube show that was a vile show regarding Elizabeth Proctor, something about oral, and that it was totally vile. And Bradl got up and said, wait a second, this is like a bait and switch. He told me he wasn't even going to even argue this bail revocation motion today. And here he is arguing this bail revocation today. And in 32 years of my career, I have never, ever, ever had an attorney tell me that they're not going to argue something and then just give me the old bait and switch and then argue it. And so somebody's saying Lizzie Proctor isn't a witness. I think the point here is, I mean, let's Erin, I know she's not a witness, but we got to focus on like what the end game here and what the whole like object here is. And in my opinion, the Commonwealth's objective is to put him back in jail and shut him up. That's what their objective is. And so when they bring in evidence that he keeps doing the things that they are telling him not to do, that could be considered felonies, even though Elizabeth Proctor may not be on the witness list, her husband is. And doesn't the witness intimidation statute, and I don't remember right now, but it's very broad. It may extend to family members of witnesses, and I'm not really exactly quite sure. But you guys are saying that that Turtle Night show, the Thursday night show was a private show. Was that his Turtle Club show? I'm not a member of his Turtle Club, so I don't know. That might have been a private show. And so somebody must have told him about it. So there must be some moles that are members of that show, and there are moles everywhere. So just beware of that. However, the judge said, isn't it true that under the statute and the laws of Massachusetts that if you were going to argue to revoke his bail, that should have been done during the first appearance? And the first appearance was in front of Judge Doolin in Norfolk Superior. So motion to revoke bail is denied. That, in my opinion, was a huge bullet dodged. A huge bullet was dodged there because, in my opinion, if he had gotten another judge, he could have been cuffed and brought right back to jail. And AIDAN has said himself that he even thought that he had a very good chance of going back to the clink today or the slammer. And so the motion to revoke the bail was denied, as was the cash bail. He released him on his own recognizance, and right now he's free. However, he's got to come back on May 15th for a pretrial hearing on these new charges of intimidating the window. And then Lana Del Turtle says that's called due process. Yes, the judge knew the law. And so there's that. We all just want the best for AIDAN, for sure. Exactly. We can argue all day about what is free speech and what is protected speech and whether what he did was violated the statute, but that's for another time. The judge's role today was to determine whether there was probable cause to bring those to sustain the charges, and he decided that there was. And so he's a very lucky man. He's a very, very, very lucky man. My other stream ended 42 minutes ago. I don't know what that's in relation to, but yeah. Did I not end it? I thought I ended it. Thanks, hey, it's me. Amy Hauser, can Bev consult a lawyer on how she rules in trial? I don't know what you mean. Does she have like an ethics lawyer? Can she look up the law? She can certainly. I mean, I'm sure that she consults with a lot of people, Amy, behind the scenes that we don't know about. And, she may talk it over with her judge buddies. She may talk. There would be no reason for her to really discuss it with a lawyer. You mean like a private attorney, like your own private attorney? No. I mean, she could, workshop it with other judges. What would you do in this situation? How would you rule? But she's got judicial immunity. So there's no ruling that she could make that would open her up to any sort of like criminal charges, if that's what you're asking me. Thank you, Romy, for gifting 10 memberships. Chloe Albert's Revenge said those aren't Commonwealth witnesses. They are alternative suspects. Who are we talking about? Chris Albert and Colin Albert? I'm a little behind here in these super chats. Thank you, though. Edward says Tully should be conflicted off investigating AIDAN. He's a complaining witness in open cases. Yeah. And he also was on all of those private text messages between Masshole Mafia, not so confidential informant Kate Peter, Tully Mello, and Lindsay Catani. Vet Girl says intent on where those cameras being there's some typos in here, placed in that direction, search and seizure of info from a public area, in my opinion. I think the camera that captured the audio is Chris Albert's camera as well. I don't know. But apparently there's a two-party consent. Massachusetts, two-party consent In order to record someone, you need their permission. What the duck? How can words that were illegally obtained be used against someone? What am I missing? Well, that is something to argue at a future hearing. But right now, in order to dismiss the charges, it's only a probable cause standard. And so that could be the subject of a future motion to exclude that at a later date. It's not a dead issue. Josh says, does Chris get a notification every time someone walks by on the street? I don't know. If it's motion censored, he might, like a Ring camera, could be. I don't know what system it is. Denise, the case to the judicial system equals the movie Airplane to commercial aviation. Thank you. This case to the judicial system. Thank you. And please don't call me Shirley. Private info. Thanks for the 50. I hate being trapped in Massachusetts due to divorce and 2 in college. This state is the worst bunch of entitled, power-hungry hacks running this state. I feel your pain. Well, I feel your pain in a lot of ways. Although I'm not in Massachusetts, I'm in New York. But thank you so much for your very generous super chat. And I am an empath, so I actually do really feel your pain. Amber Dawn, Them Johnson says, I don't know why I keep fooling myself that this attorney is fighting zealously for Turtleboy. Why not speak on the videos of Colin Albert and crew assaulting Turtleboy live in court and press about videos of Colin Albert that he committed perjury in the grand jury? But that's all, again, that's all for another day. That's all proper evidence for another time, not for today. Today was whether the charges can be sustained under probable cause, but I do agree with you, Amber, and I thank you very much for your super chat. Lil Har Oak became a member. Welcome. Luigi is here from South Africa. Turtleboy, please listen. They are not worth your freedom. You can't help Karen in jail. Thank you. Thank you so much for your super chat and for watching from South Africa. The world is watching. Craig says, at what point does Bradl tell Aidan, look, you're going to put yourself in a situation where we can't help you if you don't chill for 5 secs? I don't know what their private conversations have been, Bradl, Bederow, and Aidan, but sometimes you have a client that you can't quite control. I'm not saying that he's the client. But there are certain clients that no matter how much you give them advice, they don't necessarily want to take it. And I'm not saying that's the situation here, but I can say that I'm sure that they have, tried to gently warn him from doing such things as anything the Commonwealth could hang their hat on to incarcerate him. Double M99, can he still talk about the McAlberts on his show, the McCabe's and the Alberts? I can't opine on that. He's got a physical stay away order. It would be wrong of me to give any advice in that regard, whether it would be legal, illegal, in violation of his stay away order under the law. I would have to go back and watch the witness intimidation or read the witness intimidation statute again. But it seems to be very, very, very broad. And if he's intimidating them and trying to get them to change their testimony, or in any way he says things that may hurt their feelings, it may be considered a violation of that very overly broad law, in my opinion. Cat's Pajamas, thanks for tuning in from Canada. Example, in my mind, I have the right to walk through the park at midnight, but is it sensible? In my opinion, Turtleboy needs to back off a bit, even if it is his right. It's not smart or sensible at this juncture in time, right? And we say that with love. Thank you, Cat's Pajamas. John Miller, Melanie, that seemed dirty what Cosgrove did to Bradl, or am I wrong? Turtleboy needs to think of his kids, even though he's right. But they have guns, badges, and robes, right? And we've seen it. On the documentary last night that I watched on Discovery ID, did you see how Proctor and Buchanan, when they went to arrest Karen in June of 2022, when her charges were upgraded, how instead of going to her front door, they went to her back door? And she happened to have cameras there. And so it was caught on her Ring video. And she said something like, I don't even have underwear on, she said, and they aired it. And it's on not only their body cam video, but her Ring camera video. Why did they go around to her back door? Why didn't they just knock on the front door? Why didn't they call Yannetti? They knew she was represented. Why didn't they call Yannetti and say, we've upgraded the charges. You need to come and turn her in. You need to come and bring her in. Surrender her. Right? They didn't do that. They went to her back door. And they're intimidating. And it's gross what they're doing. It's gross. Thank you, John Miller, for your super chat. And thanks for coming to my TED Talk. Karen Reed Strong, thanks for hanging in for 12 months. Remember, we all wouldn't be here for Karen Reed without AIDAN. Pro gamer, he who laughs last. Thanks for being here for 11 months. Will Chris be at every Karen trial day to keep him out? That's a great question, Brian Miller. That's a great question because, you know, there's some conflicting stories about certain people being invited into court by the O'Keefe family to keep certain other people out of court. M. Monge, 1967. He needs to shush. We're all watching the same trial, in my opinion. I think Turtleboy should focus on evidence, and he finds and hand it over to the defense if he is able to. Thank you so much for your super chat and your thoughts. Edward, never had an attorney or prosecutor do this. Bradl needs to watch more Breenan in the Karen Reed case. Always not arguing, but I do have thoughts, yes. And I think that here's the thing, and I'm sorry I lost my train of thought on that. I think the judge knew how he was going to rule on that, and so therefore he let it be argued, because the judge came right back with the proper time for this motion to revoke his bail would have been during the first appearance. This is not the first appearance. That was in Norfolk Superior in front of Doolin because you guys brought it out then, right? And they did. And so that's what I think, Edward. But yes, it's typically not done that way, but I think the judge knew how he was going to rule. And so therefore he wanted to rule from the bench, unlike Judge Cannoni, who ruled from the bench on like what, one thing today, maybe? The most important thing that she had such grave concerns about, which she scared everyone into thinking she was going to pull the pro hoc status and then exclude ARCA. She did neither, except give them a public spanking. Little B, welcome. Thank you for being a member or becoming a member. Edward said also the camera companies all warn people audio recording may be illegal in their area. Buyer must adhere to all local laws. Good point. Cam Vadi, no expectation of privacy on public sidewalk as defense to wiretapping. No, it is a specific Massachusetts statute. If you'd like to read the Bederow letter, we can do that. I have it pulled up. We were going to read it while we were waiting. He does go through the wiretapping law. If you'd like to read it, put it in the chat. We can go back to it. I think we only got up to like page, I don't know what page we were on, of the Bederow letter. So that is not a defense. It is not, because those were private cameras. Yes, please. Okay, we will. Anakin with one Sith says, Mel, you're a hero in my book, The Guardians. Oh, thank you so much. Hanky's dirty deeds done, not cheap. Says, do you think that Peggy being mad at Turtleboy showed up today had anything to do with the turnaround on revoking bail? I don't know. I really don't know. I haven't thought about it. Hank's Spectre Speculation says, Proctor's made a public statement, door open. Well, when was that though? Last night? And when was his show about Elizabeth Proctor? I don't know. I don't know if that's what you're referring to, or if I'm just reading too much into it. Not really so sure. But that girl says, remember, none of their cameras were ever working. So how does Turtleboy know that one was working? I don't know. Were they never working? I don't know. All right, let's take a quick read through the Bederow letter that went to Chief Helena Rafferty, and it was about this exact issue, this witness statement. I mean, this witness intimidation. I'm sorry. Wiretapping. The wiretapping issue. Let me just find it here for you. Pull it back up. Because we haven't gone over that yet. That is another Bederow letter with regard to this case. Let's walk amongst yourselves for a second. Okay, move that over here. Let's see, we have 7,100 people still watching, and we only have 3,100 likes, so we really need to get that up a little bit. That'd be really nice. Thank you. Thank you very much. Okay. They're running with it. CBS Boston already has a 5-minute clip out that says Karen Reed judge scolds defense attorneys for flagrant violation during her hearing. I knew they were going to run with that. Did you know they were going to run with that? You knew, didn't you? You knew it. Here's the Bederow letter regarding wiretapping. We're going to learn a little bit more law in Massachusetts. I never thought I would have to learn so much Massachusetts law, and yet here we are. Here we are. This letter is dated March 10th, 2025. It is to Chief Helena Rafferty, Chief of Police of the Canton PD, Canton, Mass, regarding referral for criminal investigation of illegal interception of oral communications under Massachusetts General Law 272, Section 99. And this is written in the way that only my friend Mark Bederow can. Dear Chief Rafferty, along with co-counsel Timothy Bradl, I represent AIDAN KEARNEY, who is scheduled to appear in the Stoughton District Court on March 18th, 2025. That was today. We just watched it. In connection with his alleged witness intimidation of Canton Town Selectman Christopher Albert on March 4th, 2025, outside of D&E Pizza. D&E, which is owned by Mr. Albert. Okay, so that was March 4th, where that is when this alleged talking to the window happened. That matter is being investigated by Detective Brian Tully of the Massachusetts State Police, MSP. I write to formally request that the Canton Police Department commence a criminal investigation into Mr. Albert for apparent violations of Massachusetts General Law, Section 272, Section 99, interception of wire and oral communications, both generally and regarding the interception of Mr. Kearney's oral communications outside of D&E Pizza on March 4th of 2025. As detailed below, there is conclusive proof that Mr. Albert, A, repeatedly intercepts oral communications of people outside D&E without their actual knowledge, and B, unlawfully possesses an intercepting device with the intent to commit unlawful interceptions. To the extent that the Canton PD is incapable of conducting a fair and unbiased investigation due to A, Mr. Albert's position as a town selectman, which grants him oversight over the Canton PD, and your term of employment and compensation. Well, nothing like putting it right out there, Mark. In other words, Chris Albert is Chief Rafferty's boss and determines how much money she gets paid. And perhaps, she might want to refer this out to somebody else. And B, the aggrieved party bringing this issue to your attention is Mr. Kearney, footnote 1, which says, Mr. Kearney is a vocal critic of the Karen Reed prosecution and has criticized the Canton PD, MSP, and Mr. Albert, among others. C, Mr. Albert's brother, Kevin Albert, serves as a Canton PD detective. And or D, Canton PD's vigorous yet unsuccessful attempt to prosecute at least 10 individuals for allegedly intimidating Mr. Albert by exercising their First Amendment right to criticize the prosecution of Karen Reed. Footnote 2. As you're aware, acting upon Mr. Albert's claims of emotional and economic harm, the Canton PD dedicated staggering resources to prosecute the so-called Canton Nine for expressing their dissatisfaction with the Reed prosecution by protesting across the street from D&E and Richard Schiffer, who left several rubber ducks around various locations in Canton, which criticized the Reed prosecution. Charges were declined or dismissed against all these individuals after courts concluded those targeted for prosecution by the Canton PD were exercising their First Amendment rights. Additionally, as he did in the instant matter involving Mr. Kearney, on at least one other occasion, Mr. Albert contacted the MSP, claiming that he was, quote, intimidated by a mother and daughter placing rubber ducks near D&E. Not surprisingly, those matters also were dismissed on First Amendment grounds. I request that you promptly notify me whether you intend to refer this matter to another law enforcement agency. The relevant facts. D&E is located on Washington Street in the heart of downtown Canton. As the town's main downtown thoroughfare, Washington Street. Mm, is that part of that? Hold on. Okay, this is page 3. I had an extra page 2. Washington Street contains the heaviest pedestrian and vehicular traffic in Canton. D&E utilizes 2 WISE cameras. Okay, that's the system, WISE, W-Y-Z-E. One of which is perched outside, aimed directly at Washington Street and the sidewalk. There are no signs or notices posted at D&E warning customers or passers-by that their private oral communications are subject to being intercepted and recorded. As reflected in Detective Tully's March 5th, 2025 report, footnote 3, on March 5th, 2025, Mr. Albert spoke to Detective Tully at 8:15 a.m. Detective Tully completed a 6-page report and sought Mr. Kearney's custodial arrest for witness intimidation within 49 minutes of learning about the incident. See Exhibit A. The Stoughton District Court denied the request for an arrest warrant. That's what we heard about today. That's what this judge said. This judge said the first appearance was in court on March 5th in front of Judge Doolin. And if you wanted to revoke his bail, you should have argued it then, Cosgrove. Too bad, so sad, but no. Well, that was one good thing that happened. Okay. As reflected in Detective Tully's March 5th, 2025 report outlining Mr. Kearney's alleged witness intimidation on March 4th, 2025, Mr. Albert acknowledges that D&E's exterior camera intercepts and records audio from anyone within its range. Well, there you go. That's an admission, isn't it? It's not like he didn't know because he admitted it. One sec. See Exhibit A at page 2. The camera located on the exterior of the building is, quote, audio recorded. And page 5, audio is captured by an exterior camera. In other words, Mr. Albert admits that he can and does intercept and record private oral communications made by anyone in D&E's proximity, irrespective of their ignorance to the fact that they are being eavesdropped or recorded. Mr. Albert alleges that on March 4th, 2025, at approximately 10:30 p.m., he listened from the safety of his home to surreptitiously recorded video of Mr. Kearney, quote, addressing Mr. Albert and his son, Colin, about their Reed testimony. We know it's pronounced Colin, but apparently Mr. Cosgrove still doesn't know. See Exhibit A. I just want to point out also, this was a 6-page police report for a guy talking into a window. And I think that police report is longer than the motor vehicle crash report or MVA report for the pedestrian fatality of dead brother in blue, John O'Keefe. Oh, that's right. They didn't even fill one out at all because it doesn't exist. But they're filling out a 6-page report on this because Canton Select Board member Chris Albert's got a fast pass to Tully. He's got him on speed dial. And, you know, when apparently he calls, people jump. Lost my place. Although not relevant to the issue of whether Mr. Albert is in violation of Massachusetts General Law, Section 27299, the video depicts Mr. Kearney facing an interior camera rather than the audio-enabled exterior camera, which is located at the far end of the property. The applicable law. I have to say also I love Mark's use of like italicized and bold font. It's classy. Massachusetts General Law, Section 272 or 272, Section 99 requires the consent of all parties for the recording of oral communications. That is oral. So apparently you're allowed to record video of people. You just can't record sound without consent. The statute's preamble details the legislature's concern with the uncontrolled development and unrestricted use of modern electronic surveillance devices, which pose grave dangers to the privacy of all citizens of the Commonwealth. Accordingly, a stated legislative intent of the statute is to ensure that the secret use of such devices by private individuals must be prohibited. Remember also, I'm going to break to tell you, wasn't AIDAN KEARNEY didn't he also catch charges on allegedly wiretapping Lindsay Gattani by recording her crazy rant on the night in question? Not this night in question. There were so many nights in question, so many scenes, so many recordings. But apparently, she cut out the part where he said, "I'm recording this." And I think maybe, correct me if I'm wrong, were those wiretapping charges dropped against Lindsay Gattani, or on behalf of Lindsay Gattani? The wiretapping, I think they were dropped. He told her, yes, he told her he was recording, but when they edited that video, shocker, I mean audio, they cut that part out, right? So was that, it was not dropped? So that's still pending? He's still facing wiretapping charges? Thank you, Suze. So he's still facing wiretapping charges. That was 12/24/24. So it was Christmas Eve 2024. And that was those charges led to his bail being revoked that time. And then he spent 60 days in Norfolk County Jail with Brian Walsh. They wanted to keep him in there for 90. But after 60, they realized 60 was the limit and they had to let him out. And they didn't want to. He still has the wiretapping and witness intimidation. Thank you, Laura. Okay. That was 2023 or 2024? 2023? Yeah, I want to get it right. I think it was 2023. Was it 2023? Yes, 2020. Okay, good. We're correct. The record is now. Let us reflect. The record is now corrected. It was Christmas Eve 2023 when allegedly AIDAN KEARNEY was set up by the combination of Tully, Mello, Lindsay Gattani, and not so confidential informant Kate Peter in group text messages in which they perhaps set him up and served Lindsay Gattani with a summons for a fake grand jury that one had already concluded. One hadn't even been convened because there were no charges yet. They served Lindsay Gattani with a subpoena to testify in front of a grand jury, but there was no grand jury. That made her a witness. And then what he did constituted, in their mind, witness intimidation. And he's got the wiretapping charge too for tape recording that crazy ass conversation. Not so informed informant mess, whole mafia. But somebody says the wiretapping charge was dismissed. I don't know. I can't seem to get. He's facing assault and witness intimidation charges. I thought the wiretapping charge was dismissed too. So now I'm a little confused. So let's table that for later. But in any event, let's keep going. Accordingly, a state legislative intent of the statute is to ensure that the secret use of such devices by private individuals must be prohibited. Unlike the Fourth Amendment, Massachusetts General Law 272, Section 99 provides protection to an aggrieved person, a non-consenting recorded party, even where that individual does not have a reasonable expectation of privacy. Citing some cases. Consequently, a recording made on a public sidewalk or thoroughfare may violate the statute. Under the Massachusetts statute, a recording is made secretly and thus illegally where it is made without the actual knowledge of the person being recorded. This means that Mr. Albert has no absolute right to record oral communications made by someone positioned on a public sidewalk or street within range of D&E's audio camera. Yet this is precisely what D&E's exterior camera is set up to do. Mr. Albert's blanket audio recording of individuals outside of D&E without their actual knowledge constitutes a felony under Massachusetts General Law 272, Section 99C1, which states that any person who willfully and secretly audio records another without prior authority by all parties to the communication is guilty of a felony. Significantly, the statute contains an evidentiary presumption that proof of the installation of any intercepting device by any person under the circumstances evincing an attempt to commit an interception, which is not authorized or permitted by this section, shall be prima facie evidence of a violation of this subparagraph. Put simply, Mr. Albert's installation of a recording camera, while aware that it would record audio without the actual knowledge of the intercepted parties, conclusively establishes that he is in violation of the statute. Additionally, separate and apart from the March 4th, 2025 incident, Mr. Albert's mere possession of the camera with the intent to audio record another without his or her agreement constitutes a misdemeanor under Massachusetts General Law 272, Section 99. I would submit to you also, and I think Mark Bederow has said, each and every instance of recording a person on the sidewalk would be a separate charge. So there's that. Other factors warranting an investigation. Hold 1 second, please. No, there's been no ruling on the motion to dismiss yet. No ruling yet, somebody just said. Okay. It is essential that the Canton PD be even-handed in determining whether to investigate potential criminal violations without regard to any relevant party's views on a controversial matter of public concern, such as the merits of the Reed prosecution. Yeah. You can't selectively prosecute. Okay? What's good for the goose, my friends? Just because Chris Albert may be a friendly to the Canton PD doesn't mean that he should not be, as such, prosecuted under the same laws that they're using, that they are weaponizing against people who don't think John O'Keefe got hit by a car. Okay? That's just not the way that justice is supposed to be meted out. It's just not the way that charges are supposed to be brought. Did somebody say that? Turtleboy's in the chat. Hey, you dodged a bunch of bullets today, my guy. Aidan, if you're here, I don't know. I thought I heard somebody talking to you. Was it hard for you not to laugh when he kept saying colon? Dude, really? How did nobody correct him since last time talking about Colin Albert? And so there, that was, I was laughing. I was laughing because the whole thing was comical until the point where I thought the judge was totally going to revoke your bail and also cuff you and put you in. So you dodged a whole bunch of bullets today. Praise be. Praise be. Very lucky. And they're out to get you. They are out to get you. You know that. You know they're out to get you. I don't want to sound like your mother. May she rest in peace, by the way. But they're out to get you. And they will stop at nothing, in my opinion. Got your actions accordingly. And I'm not your lawyer, so I can say that to you. I'm not here to give legal advice. It's coming from a place of love. Moving on to the Bederow letter. Back to the Bederow letter. Here, there is overwhelming evidence that a town selectman and longtime business owner is violating the law and flagrantly invading the privacy interests of anyone who makes oral communications within range of D&E's exterior camera. Failure to investigate here will lessen the public's confidence in the Canton PD's ability to apply the law in an unbiased manner and to protect the public without regard to a possible offender's prominent political status in the community, his family's close relationship with the Canton PD, and his involvement in and enthusiastic support of the prosecution of Karen Read, or persecution. Moreover, wait, was that page 5? I just want to make sure because these might be out of order. Okay. Moreover, Mr. Albert's prior dissemination of recordings from D&E cameras to mock supporters of Karen Read at the same time, he has repeatedly and unsuccessfully accused several of them, of intimidating him, is troubling and supports the need for an investigation. On September 26, 2024, Mr. Albert arranged for the public release of a video from one of D&E's cameras to humiliate an individual who had the temerity to peacefully exercise her First Amendment rights by writing FKR, Free Karen Read, on her vehicle window while it was parked in front of D&E. Mr. Albert recorded himself watching this video. He referred to the woman as a loser and a disgusting biatch, and then instructed someone to take her picture. Within a few hours, this video was provided to Catherine Peter, aka not so confidential informant, aka mafia masshole, who promptly posted it on X. Well, of course she did, because she's their mouthpiece, isn't she? See Exhibit B. It stands to reason that if a town selectman is undeterred from making such inappropriate comments about his constituents or town visitors, and he is brazen enough to publicly disseminate the video to shame someone exercising her right to free speech, he is more than willing to secretly intercept and record oral communications made by others outside his place of business. For these reasons, we request that the Canton PD investigate whether Mr. Albert's interception of oral communications with Mr. Kearney on March 4th, 2025, or of anyone else within range of the cameras located at D&E violates Massachusetts General Law 272, Section 99, XOXO. Mark Bederow, CC, Timothy Bradl, AIDAN KEARNEY. I see in the chat people are saying, I think the Canton PD will do nothing. Yeah, but you know what? You know what they need to do? They need to address it. Because first of all, what she should do is recuse herself from this investigation and refer it out to a different department or a different body, because Chris Albert's brother is a detective with Canton PD, and so they're conflicted out. She has an obligation and a duty, in my opinion, to refer it out if he's breaking the law. And, he admitted to it. Bederow does nothing if not bring receipts. And so there's that. Nathan says the Virginia state motto applies better here. Thank you, Nathan. After the admission of McAlbert about camera, what needs to happen for them to take, after the admission of Chris Albert about the camera, what needs to happen for them to take it down? Usually late to the party. Can residents press charges? If anyone know, how about the woman that was that put Free Karen Read on her car? Was there audio with that video as well? I guess you would have to know that it actually did happen to you. Brennan, you saying, Cindy? Needs scolding? Thank you. Was there also audio there? What news station had the Courtney Proctor statement? Well, I'm glad you asked, because I have that here. So we can take a look at that if you like. Let's just pull that up. As you know, why not just be here all day? Why not? We're here, right? Why not just keep the party going? Let's see. It must be in my history, because I know I watched it yesterday. In addition to, the arraignment of that guy in Hyannis, our friend Tom Kokonowski is representing the alleged shooter. Turns out, all right, so his name is Green, I think. Alex Green is the defendant in that case. Tom Kokonowski is his attorney. There's a YouTube channel called hyannisnews.com who actually did film the arraignment, and I don't want to play it because I commented on it and they took my comment off. All I said was, good job. Thanks for posting this. I don't know. So Tom Kokonowski is representing that defendant. It seems that, from what I gleaned from the arraignment, that the decedent exposed himself to the shooter's wife, and that's when he shot him. Man, it also seems that, according to my own research, when I Googled the decedent, he had been sentenced to 75 months in prison in a conspiracy charge to on a heroin ring where a bunch of other people were imprisoned. He was sentenced to 75 months in 2023. So why was he even out of prison? I don't know. So there's a lot of issues. Tom represented you back in 2000. We love Tom. We love Tom. We saw Brian Camp be acquitted, and Tom is amazing. And so if this is in any way a self-defense case, which it may be, I can't wait to hear more. So if somebody can point me in the direction of, well, you know what, I'm just going to have to Google it on YouTube. I thought I watched it. So what news channel was it that had the video of Courtney Proctor and Elizabeth? Why is all this other stuff coming up here? Channel 5, thank you. WCVB. They don't make it easy. Oh, there's the stern warning video. Hold on. WCVB, Channel 5. Okay, I'm in here now. I just have to scroll through all their dopey videos. Oh, got it. All right, hang on. We got it. I'm going to put on the closed captions because the audio is not great. Ready?
More than 3 years after Trooper Michael Proctor got a call to investigate a body in the snow, his wife Elizabeth and his sister Courtney say they had no idea how much their lives and their families' lives would change, including for their young children.
But that's sort of what breaks me, is when I see them playing and so happy, and I'm like, God, they have no idea.
She's talking about her children. And if your children have no idea, that's probably a good thing. This is, I think this is the wife. Yeah. Hang on.
Families' lives would change, including for their young children.
But that's sort of what breaks me, is when I see them playing and so happy, and I'm like, God, they have no idea that their parents' world is crumbling.
Karen Reed's defense has accused Proctor of trying to frame her for the death of John O'Keefe, including by planting pieces of her SUV taillight at the scene. Is there any doubt in your mind that Michael Proctor might have framed Karen Reed?
No doubt whatsoever in our mind. No doubt whatsoever, and the evidence shows that.
No doubt that he did, or no doubt that he didn't? Because it's kind of not clear. Is there any doubt in your mind that he framed Karen Reed? No doubt at all, right?
For the death of John O'Keefe, including by planting pieces of her SUV taillight at the scene. Is there any doubt in your mind that Michael Proctor might have framed Karen Reed?
No doubt whatsoever in our mind. No doubt whatsoever, and the evidence shows that. The investigations show that.
During Reed's first trial, Proctor did admit to writing insulting text messages about her, including that he hoped she would kill herself.
Because the evidence pointed to this woman killing a fellow Boston police officer. So he was angry. He was upset by that. So I understand the need that he had to vent to friends, whether it was appropriate or not.
Elizabeth and Courtney Proctor say those messages.
Was it venting to friends when he said that he was looking for nudes? and commenting on her physical appearance. He's your husband. I wouldn't defend that if I were you.
Messages do not justify the harassment they say they've received from Reed's supporters, including rocks thrown in their yards and anonymous voicemails like this.
I'm going to be your kid's new mommy, and I'm taking your kids and I'm taking your dogs.
A blogger named AIDAN KEARNEY, who goes by the name Turtleboy, has been charged with witness intimidation in this case, but the Proctors say he's not the only one responsible.
It seems like Karen Reed and AIDAN have been conspiring and colluding.
Now, prosecutors have said that Kearney and Reed have been communicating, but at this point, she is not charged with witness intimidation. Recently, the prosecutors confirmed that a federal investigation into potential misconduct connected to the Reed case concluded without charging Proctor or anyone else. His family say that the feds checked 5 years worth of personal emails and text messages and found no other problems. Live in Canton, David Beanick, WCVB News Center.
Okay, readjust your volume. First of all, who's that reporter? Never seen him before. Second of all, somebody was throwing rocks on their lawn. Did I hear that correctly? That's one thing we need to talk about. Number two, they went through 5 years of his messages, and that's all they could find, he said. And then I heard somebody saying that the trolls online were going crazy, that how dare they go through 5 years of his messages, and that's the only thing that they could find was they went through 5 years of his messages. Here's the thing. If you're a public official or you are in the public service and you use your private, let's say, email server or private electronic device, your phone, to do such things as conduct company business or police business, it becomes open season. And, the feds got it. So, I don't know. It's not open season right now for us to bash, the Proctors, the wife and the sister. And, I'm sure they're going through a lot and it's very sad, but I am very happy that the children don't know what's going on because that's better. It's better for them. It's better for them. Rocks are similar to bleach on a lawn. Neither should happen. I don't know. I don't know what they mean. Like people are throwing rocks on the lawn. So nobody should be throwing bleach balloons on anybody's lawn either. I'm not, in fact, like defending any of this, but I just think that the public statement that they gave may have backfired on them. And thank you so much for bringing this up, Al Dente. And this is exactly why I kept this comment in escrow, because you made this comment at 12:29 p.m. and now it's 2 hours ago. Did you see Courtney Proctor News 5 last night? She did a Freudian slip, in my opinion. Thank you. And you're back in Canada and you just made that comment again. And I think that's what it sounded like. Do you have any doubt in your mind that Michael Proctor framed Karen Reed? And she said, no, absolutely not. Absolutely not. I have no doubt in my mind. So I don't know. Wise, not wise. Oh, see how you guys change your name, just like on the spur of on a spur of the moment sort of thing. It says trolls be gone. Trolls be gone. And I want to see who posted this before I play it. So I won't play that. But I do have for you a video. Karen was on. Karen was on the Glares show last night. She came on. Thank you, Wise Not Wise, for your 5 and for thanking me. And says trolls be gone. We play Whack a Troll here on a regular basis. And Angie says, I'm so thankful for me. You're thankful for me. I'm thankful for you. You make my workday exciting as a work from home employee. Oh, that is sweet. Thank you. Let me see if I can pull up my edited video and if I can even get it to play through StreamYard, because StreamYard's been a little bit wonky lately. But Karen did go on Glare's show last night, and she smiled for the first time in a long time. But I'm not sure if it will play the audio the way I have to do this. So just give me a second. I may have to download it and then play it as a video clip. So hold, please. No. Let me see. Let me see if it'll play if I do this. Hold on. StreamYard sold another company, to different people, and they doubled their prices, and the service is 10 times worse. So, you know, there's that. All right, let's try this. Nope. To share audio, share a tab instead. Well, that's not a tab, it's a window. So I don't think you're going to be able to hear this, but can you hear it? Can you hear it? How can I download this? All right, hang on. Give me a minute. I'm gonna download it first, I think. All right, I figured it out. Hang on one sec. Okay, got it. Look at me. You know, one of these days, you guys, it's gonna be wild. It is gonna be so wild when I am just technologically so savvy that I can really, I mean, I already do this by myself, but I'm gonna be doing it, you know, in a really seamless way. In a seamless way. It's gonna be fantastic. And you're gonna really enjoy it. Hmm? This can happen if the video is invalid. Contact us if you need help. All right, maybe it needs a minute. Maybe it needs a minute. All right, let's try it again. Contact us if you need help. You're not going to answer me. Talk amongst yourselves for a second, because this was really nice. Karen is smiling. It never happens. It's nice to see it. I will give everyone a little bit of joy.
Yeah.
Yeah.
Let's keep it easy for you. So how do you feel about a documentary that's supposed to start airing tonight? Do you feel confident about it, that it's going to air you in a good light, or?
Yeah, I don't feel overly confident about it. My relationship with Terry kind of broke down the deeper we went into this. Terry was supposed to be a fly on the wall, and she became kind of a fly in the ointment, and it was just a lot. She probably filmed, if we did back of the envelope math, 400 to 500 hours, and I've been in touch with several people who had a screening of it and relate. So I have not seen it, but I know people who have, and I would have hoped she would have used more of the access she had to us, and instead it sounds like she might have scraped the barrel in terms of opposition, because that's kind of all there is, to speak against the FKRs. So I'm not optimistic. What I've heard is that it's not awful, but given what she had, I mean, she had us waking up, going to bed, arguing, the car rides to and from court, dinners on the weekends, home with our families. I mean, she had it all. And my understanding is not much made it in. She interviewed people I used to work with. She interviewed former students of mine, relatives, people like the Roccos. I don't know if she interviewed AIDAN, and every one of these people that I just mentioned received a notice from Terry's production company that their interviews did not make it in. And my understanding is people who are, what I'll say, easily accessible in media, social media, court TV, they all made it in. So it sounds like she went out of her way to strike a balance, but I don't really know how balanced it is. So I am not going out of my way to catch this. I have not watched my own Dateline, and I've watched about half of 2020. And part of it is a personal challenge that I have so little control over my life, and I'm a controlling person in a lot of ways. And I have so little control that it's almost like a game I play with myself, that if I'm skeptical about this or skeptical of how I'm portrayed on Dateline, I will not let it infiltrate me. And I'll tell everyone around me, I don't want to hear about Dateline, or I don't want to hear about the document. If it's negative, I don't want to hear it. If there's negative things that are important for me to know or I should be aware of, I'll find out about it. But I do take some pride. I'm picking up Liza, and as soon as she gets in the car, I'll have to leave, or else we'll be breaking the gag order, unfortunately. But Liza and I are going to go out to eat. Then we have a conference call. Actually, no, I take that back. It's not a conference call because everyone's here now. Alan's right behind her. David's at the hotel, and Bob's coming in. Bob doesn't really sleep, so he comes in the middle of the night. But we'll be discussing our strategy for tomorrow and just dividing and conquering these motions in limine. But I want to say before I went in the tunnel under the harbor that when the mistrial was declared, and then we engaged with Marty, which was at a discount, but still a significant expense to me, I never thought I could supplement or enhance my witness list, our case in chief, with what little resources I had. I sold my house, but the expenses that I've had to incur to get here long surpass the equity I had in my house, and that is solely because of the people watching, the people on this stream, the three of you who have helped raise awareness and have these shows.
Man, every time she tries to
That's
make
where
this
she got
point,
cut
she
off.
goes into a tunnel.
So you can adjust your volume back to normal. It was nice to see her smile, right? Agreed. Thank you, Sherilyn, for your Cash App. I appreciate you so much. And Nina, if I didn't thank you last time for the $11 Cash App, and that was like on the day of the full moon, Mercury in retrograde, all kinds of things like that. AJK points out the Boston Globe Spotlight team earned the 2023 Pulitzer for public service going after the Catholic Church. Shout louder. Yeah, I was involved in those cases on Long Island. I was not in that documentary, or that movie, I should say, because it was fictionalized account of actually what really happened. But I did handle all of the cases on Long Island, most of them anyway, for the victims/survivors of clergy SA here on Long Island. And so I was heavily involved in those cases, and that was like a 16-year fight. So yeah, I know them well. Amisthet. Why did Karen not make sure her contract insisted on final approval? Crazy. I would never do any interview, etc., without final approval. I will point out to you, she was not paid for that. She gave them unfettered access, and that was not part of the deal. However, I was also asked to participate in that exact show, and I declined for that exact reason. Because when you do a documentary like this with a Discovery ID channel, or any channel really, they can edit you. Any reality show, I would never recommend anybody ever do a reality show. It can do nothing for you but ruin your life. They can make you and edit you to look however they want, and take things out of context. And I did not see any upside for me to be in that documentary. And they reached out to me. I mean, I want to say it was like March of 2024. So it was way before the first trial. Not way before, but before the first trial. Other people did participate. Like I think Brian from LTL did. I think everyone who was a creator that did participate was cut. And they kept in. Turtleboy declined, but he was under contract with someone else. That's why he was under contract with Mark Wahlberg, and so he had to decline. Jamie, I just saw that comment fly by on my phone. I didn't see any upside. She had nothing to hide. Yeah, she had nothing to hide. But again, the outtakes, I think, are going to show some context around what they showed last night on that show, which was she admitted to having 6 drinks. She admitted that her vodka soda was in the center console, and John grabbed it when he got out of the car. And you see how juries can misconstrue things if they're not in the proper context. And I don't know what the real story is and if it was taken out of context or not. But what I do know is if the jury has showed those clips in the way that they were shown last night on Discovery ID, they could be very damaging in the eyes of a jury. That's my opinion. We will never hear the end of the documentary from Hank. Yep. Yes, I saw Richie briefly from Microdots, was in there a little tiny bit. He was. Yep. Context is everything. Thank you, Green Eyed Southern Girl. Hi, Magnolia Gypsy. Says, this was my point when someone on the cesspool was trying to make something out of creators that didn't participate. Y'all know better. Why there was no upside for me, right? They don't pay for you to be in it. They didn't pay Karen. They don't pay anyone. They want your content. They want you to come and do your thing for free. They want your content for free. And they're going to profit off of it and potentially make you look really bad. So Brian said he did participate. Yeah, but I think he was cut. I think all the creators that participated were cut. So there's that. 2 more episodes are going to drop tonight. So that should be another 2 hours tonight. And I guess another hour. Scroll farther on Glare as Karen comes back. No, actually, I screen recorded that. So that was actually on my phone that I screen recorded it. So I can't because I wasn't playing his stream. I was playing my own screen recording. But you guys should go watch that later. It was on Glare's show yesterday. Just fast forward it through to the part where Karen comes on. I think it's kind of near. It was a 12-hour stream. So it was kind of in the beginning. Magnolia Gypsy says exactly they don't pay and then they manipulate how you look. Yeah, there's no upside there. For me, there was no upside. Maybe somebody who wants publicity or who's looking for clients or, but again, big case Mike. Look how they make him look on Court TV and the things he said about Karen Reed. I hate that one. I hate that. You think anybody's hiring big case Mike? I don't think so. RB's been here for 2 months. Free Karen Reed, Aidan Kearney, Justice for Officer John O'Keefe. Thank you so very much. Does anyone know where I can watch in the UK? I don't know where you can watch it on the UK. Can anybody in chat help Becky B? I know here in the US it's on Max and Discovery ID. Samantha, thank you so much. Says thanks for all you do. And I also appreciate the clean language. You are very, very welcome. And everybody else that I need to thank here. Thank you, Donna, for buying 3 matcha lattes. Says I can't take much more of the judges in Massachusetts today. Well, I think Aidan got lucky. She says, love your channel. I love you back. I love you right back. Thank you to my moderators today for keeping it classy. This is hard. It's hard to cover Aidan Kearney and Karen Reed in the same day. But you know what? You guys are rock stars. I could not do this without my moderators. They're amazing. They really, really, really are amazing. I did whisper for your comfort because we had to modulate the audio and it was really bad. And Wise Not Wise wants a green hoodie with free Karen Reed on it. Is there no green in the spread shop? Max TV or ID channel in the UK? No, you are, little cupcake and Scott Messerschmidt and Team Brittany and 25 years kindergarten cop. Kindergarten cop might have checked out. He might have been like, I am out of here. And Team Brittany and all of my amazing moderators, Sarah and Shog and Hara, and all of you guys who hang out with me every day and do the things and stuff and Scott Messerschmidt, because you guys really, I couldn't do it without you. You're awesome. And to everyone, please kindly hit the like button. It helps with the algorithm. I'd really, really like to get my 100,000 subscriber plaque. I've only been doing this channel for like a year and a half, and we're already up to, let me see how many. Did we hit 80,000 yet? No, we're at 79.5. 79,500. And once I get to 100, I get that silver plaque. Vinny Politan has one, and I'm in a competition with him. And he knows about it now because I told him last time he was on my show. Deborah says she mentioned they were buying her drinks maybe to impair them. She mentioned they were buying her drinks. Yes, she did. But she also said, I thought she admitted last night that she had 6 drinks. Now, it could have been taken out of context because she could have said before that, I kept pouring, because she said something like I kept pouring the shots into my drinks, but I wasn't drinking them. But the way it was edited last night, I heard she had 6 drinks. Thank you, Magnolia Gypsy. Please subscribe. It is 100% free. And listen, when Vinny Politan was on the show, and because he said that he has a personal bias against drunk driving, because when he was a child, his neighbor's entire family were killed in a drunk driving accident. A lot of people also share that personal bias against drunk driving for personal and or maybe not so personal reasons. And so something like that gets in, and you heard what the last jury said when they were like, well, she was drunk. They were both there. Someone's dead. Therefore, she did it. And that's not, in my opinion, it's not the just result. M. Mange, 1967, is still wanting nothing to see here sweatshirt. Nothing to see here sweatshirt. Yeah, when I can, I will. When I can, I will. And right, Bolshevik Muppet says, I respect Vinny for acknowledging his bias. And we all have biases, and jurors do too, and they come into court with them, and it's hard to put them aside. I don't think he was hit by a car either. That's how I got involved in this case. I agree, James. I am 100% with you. John O'Keefe was not hit by a car, or did not hit John O'Keefe. The injuries don't line up. I've been screaming that into a closet since I started covering this case. That's the reason that I got Garrett Wing to come on my channel, because Jennifer Koffendorfer tried to make me look like an a-hole on court TV twice because I said that. And so I got Garrett Wing to come on my show, and now he's on the defense witness list, and the Commonwealth is afraid of it, and they want him out. It is ridiculous. He wasn't hit, Ann, but we know a lot more about this case than 12 people who are going to come in knowing nothing about this case, listen to a whole bunch of spaghetti on the wall. And there were people on that jury, and we heard that from Ronnie, who thought she was drunk, therefore she must be guilty of something. That's all I'm saying. Okay? Thank you again to the moderators. Yes, that was said, never say never. Karen did say that last night on the documentary. She pulled a piece of glass out of John's nose, I think she said, and then it started bleeding. That's what I heard last night. I'm going to go maybe watch it again. Oh, it was kind of painful. So hi, Valerie. How do I send memberships? I sent money, but forgot to add my comment. Hi, Valerie. I see it. Thank you so much for your super chat. Put your question in the chat and I'll watch for it now before we wrap. Thank you, Valerie. I appreciate you. Yes. He pulled a piece of glass out of his nose. She said she pulled a piece of glass out of his nose, and then she started to bleed. And then people are like, well, dead people don't bleed. And remember, somebody said that there was a thready pulse. He may have still have been alive. And so, Valerie, if you're still here, just put your question in so I can see it. And just Jake wants to know if we can do a quick Turtleboy update before closing. Yes. Turtleboy's charges, his new charges, were not dismissed. He pled not guilty. The judge refrained from giving him any bail, released him on his own recognizance, and did not revoke his bail in his other felony cases because he said that those should be, that you should have brought that up during the first appearance in front of Judge Doolin. Those are the rules. Sorry, too bad, so sad. And so there's that. Valerie, I'm still waiting for your comment. Oh, I might have it on slow mode, so I'll give you another minute. Deborah says she mentioned they were buying her drinks, maybe to impair them. Yep, I think I already read that. And let's just wait for Valerie before we wrap because I'm getting tired. There is no court tomorrow. They are coming back on Thursday at 9 a.m. I don't know why. We were supposed to. The motions for the defense have been locked. All right. Valerie, there's a song for you somewhere in my head. Thank you, Mama She. Love, love, love your coverage. Always glad to be a cupcake. Always on top of things. Mama She, no, you're the best. You're okay. Another episode tonight. Yes, yes, yes. No court tomorrow. We're coming back for Karen Reed on Thursday at 9. All right, Valerie, I'm not seeing anything from you, but hi, Kindergarten Cop, who says, in my opinion, Bev has to meet with Marcy and get the next playbook. Yep, that's what it is. It's Valerie by Amy Winehouse. I should know that because one of my daughters plays it in the car all the time. I love that. I love it. You're a B, bro. John was still alive in the snow. She was trying to save his life and took the glass from his nose to do mouth to mouth, right? Turtleboy's hearing was live. Yes, it was. We streamed it. It was on Zoom. We got it. You can rewind. You can rewind and watch it. It was interesting because we were really on the edge of our seats. We really, really, really thought that he was going to revoke his bail. He dodged a bullet. Thanks, Winnie Lombard, who says, love you. Thanks for what you do. We love your commentary. Ignore the trolls. I didn't even see them today. I'm not going to pay attention anymore. We thought today was going to be a full day too, but it wasn't. And we thought tomorrow was going to be a full day, but it's been pushed to Thursday at 9. The title of the show on ID is called A Body in the Snow, the Karen Reed trial. Okay? All right. Thank you, moderators. I love you with all my heart. If I don't see you soon, I'm not going to die. Members, channel members, you're the greatest. Everyone who sent a super chat in today, I can't thank you enough. And please hit the like button on your way out. And thank you so much for being here with me on a daily basis and listening to me as I rant and scream into the closet. And oftentimes you say that I often say what you're thinking. So until next time, if you weren't here for the morning stream, go back and watch that, because that was wild in the courtroom of Judge Beverly Canone. And stay cool, stay kind, stay classy. I will see you real soon. And stay safe. And hey, Mel, not hey, me, says Angie. Peace, my friend.